I have not been released by the DDSC. Now I have no posting place, my lord. I am just
No, that
sitting.
is why they'll
Yes.
let them decide within 15 days
No, my
whether to
lord.
release
This
or
otherwise, my lord, that page 21, my lord.
what is that?
This is a order by this honorable court, my lord. Similarly situated person, my lord.
Now we do not know what
My
is the
lord.
reason,
My lord, that
because it may so happen that in the state school, maybe that the reliever has not come.
no, my lord, no, yes,
For
no,
in that school where you have been from where you have been transferred,
my lord.
so there probably no teachers have been posted.
No, my lord, that
And what he is saying is they have already forwarded before the deputy commissioner. It is pending before the deputy commissioner. They will decide it.
my lord, otherwise the authority is the DDSC, my lord. But my lord will just this page 21, that order, my lord. My brother had also consented for this order, my lord, in earlier, my lord.
Within
This
week,
WPC 461, my lord, is similarly situated person, my lord. TGT biology, my lord. Similarly situated person transferred by the same order, my lord. And the actions impugned is also same. She was not being released by the deputy DDSC.
Okay. Well,
On this line, my lord, the same order can be passed, my lord.
is it okay?
no, it can be done, man. I've talked within 2 weeks they will be released because because of the procedure lapses, but because of the
Okay.
deputy commissioner.
Heard, Mr. Okay. Now counsel for the petition. I've also heard Mr. European. Standing counsel, education department. So, para. The case of the petitioner is that white order, where is white order dated 8/2024, issued by the director, the respondent, director is respondent.
Respondent number 2, my lord. No, my lord. The director is not in the party, my lord. I'm sorry, my lord. But it's been released by the transfer order issued by the director, my lord. Secondary.
Director is not a party.
My lord. Inadvertently, my lord. That, my lord.
The director of school education, secondary education, government of Arunachal Pradesh. White. Order dated 13/8/2024 has transferred the petitioner, who is working as TGT biology from Government High Secondary School, Chayangtajo, East Kameng District, to Government High Secondary School, Chongkham, Namsai District. However, pursuant to the said transfer order, so not however, pursuant to the said transfer order, the petitioner who is this? ADC.
Yes, my lord. The submission by.
ADC has released.
No, my lord. The approval was ADC approval has also been sought, my lord. Will see, my lord. And down below by the principal, my lord. At page 16, my lord. by the principal and
Pursuant to the said transfer order dated 13/8/2024, comma, by an order dated principal. Okay, by an order number DAC 11012/1/2024, dated 18/11/2024. The principal Government Higher Secondary School, Jayantajo, within bracket respondent number 3, on the approval of the ADC Jayantajo, has issued a release order. No, released. He issued a release order. Then release the petitioner from the Government Higher Secondary School, Jayantajo, in order to enable him to join at his new place of posting. However, in spite of issuance of the transfer order and the release order issued by the principal of the school, comma, the who is not releasing?
DDSC, my lord.
The respondent number
Two.
the deputy director of school education, East Coming District, said part. Respondent number 2. He is to release.
My lord.
Who is to has not yet released the petitioner from not yet issued the release order. So it is submitted that in the inter-district transfer, in case of the district transfer, the release
Approval.
of the deputy director.
Approval of deputy commissioner is
Okay.
required,
Okay.
and
The
DDSC.
release, the person has to be released by the deputy director of the school education with the approval of the
on approval of deputy commissioner,
with the approval on the approval of the deputy commissioner of the
concerned district.
concerned district. Stop. Case of the petitioner that on non-release of even after the issuance of the transfer order, on non-release by the respondent number 3, even after the transfer order issued by the director and the release order released by the principal of the concerned school, the petitioner has submitted an application before the respondent number 3, respondent number 2, praying for his release from the Government Higher Secondary School, Jayantajo, in order to enable him to join in his new posting place at Chongkam, Namsai, Government High Secondary School, Chongkam, Namsai District. Stop. When this application was made,
And this was on
However,
18.
however, despite of the
18
said request made, the respondent number 2 has not yet released the petitioner, hence this petition. Hence, by filing this petition, the petition under 226 of the Constitution of India, the petitioner is seeking direction for release of the petitioner Stop. The Atlantic Council for Petitioner submits that in the similar case, the petitioner, in the similar case, where the petitioner was not released, comma, this court in, where have you stated?
Page 21, my lord, Sri Judge. So, WPC
Yes,
461. The same transfer order, my lord.
The same transfer order,
Same transfer order.
okay.
From SEPA only.
In WPC 461/2024, comma, the authority was directed to
Your lordship would come to page 13 for a moment, my lord. 1-3, my lord.
what is 1-3?
1-3 is the transfer order, my lord. And I am at serial number 5, my lord. Serial number 6 is the petitioner in 4-6.
Okay. In the similar nature arising out of the same transfer order. When the same arising out of same transfer order, when the authority concerned did not release the petitioner who is at serial number 6, comma, the petitioner approached this court and by an order dated 22/10/2024, comma, this court has directed to the respondent, more particularly the respondent number 2, to issue release order within a period of 15 days from the date of receipt of the certified copy of the said order. So the petitioner is praying for similar direction. So, in this petition, comma, the petitioner is seeking direction, seeking similar direction. Stop. Mr. Topung, the Standing Counsel for the Education Department, you are representing all.
Yes, all, my lord.
Okay. All the respondent submits that for inter-district transfer before inter-district transfer, the approval of the deputy commissioner of the concerned district is necessary obtained before release of the incumbent. However, he submits that the respondent number 2 has already forwarded the case of the petitioner before the deputy commissioner for his approval, and the same is likely to be complete within 2 weeks.
My lord.
As pray for some time.
My lord, instead of forwarded, my lord, it would be appropriate, my lord, put up.
Has already put up, huh?
Yes.
The case of the petitioner. Okay. Okay. Got it. Having heard the submission made by the Atlantic Council for both the parties, this court find it fit and proper to dispose of the instant writ petition at the motion stage itself with direction to the respondent authority respondent, more particularly the number 2, either either to dispose of the representation dated. This was submitted on
18/9.
18/9/2024, or to release the petitioner from government higher secondary school, Chang Tajo, so as to enable the petitioner to join his newly posted place at Namsai, government higher secondary school, Chongkham, Namsai district. Stop. Such exercise shall be completed within 15 days from
Well,
the date
that
of
of receiver.
date of receipt of certified copy of this order. With the observation made above, this petition stands disposal.
Pray for slight modification. Since my brother has already said that the petitioner will be released within 2 weeks.
Well, that will suffice, man. 15 days.
Yes.
So,
So, my lord,
yes,
yes, my lord, instead of the disposal of the representation, my lord, can that be done away with?
Either-
And can the
No.
because otherwise then they might do something else, my lord. Because in this earlier petition also, the submission of my brother was that due to some communication gap, there has been some delay. Similar
The putting up is for release.
putting up for approval. On approval, he'll be released, man.
Okay, then this disposal of representation is not necessary.
that may not be.
Okay,
Yes.
then leave that part. Dispose, release within 15 days. Okay.
Deeply.
Oh, Lord.
My lord, sorry for the interruption, my lord.
This was 8. Yes. Yes. Who? Okay. Yes.
May I tell you?
Yes.
Well, this is an application by Farm CR Enterprise, who was awarded a work order for supply under the MG Enrega in the month of January. Now, the time frame was within 6 months he has to supply. But in the meantime, 3 things happened. One is there was a bridge collapse in Kurung Kume, the Kurung Bridge. Second is the general election. And thirdly, there was a stay order by the Supreme Court for which within these 6 months, at least three to 3.5 months, I could not work. Now, therefore, I submitted a representation that there is a clause mentioned in the agreement extension. That representation has not been considered. Now a fresh tender has been floated, and I have made a statement that for the remaining, I have made supplies, but around 40% supply is left. Now for the remaining part of my supplies, a fresh tender has been floated. There is some delay in approaching because the authority gave me assurance that your application will be considered because all the ZPMs, they themselves on my behalf and all other similarly situated persons recommended that they should be given extension. And as far as the petition is concerned, if he gets an extension of at least 2 weeks, he can complete it. But instead of giving him 2 weeks, when the terms of the agreement itself provides for extension, they are going ahead with a fresh tender. That is my case. I'm just showing you, Lordship. Page 30 is the first NIT pursuant to which I was awarded the work order. Page 30, notice inviting
This
tender.
was in August 23.
August 23. Pursuant to this, I was given the work order. item rate tender is hereby invited on behalf of the government of Arunachal Pradesh from all registered and eligible contractors and vendors firms having trading license with GST registration for supply and procurement of materials. This is the work. Supply and procurement of materials pertaining to MG NREGA works 2023.
Supply of what? What
Sup-
material?
Materials basically for construction, food items, etc. And on the table given in the middle shows that it is for the second row, supply and procurement of materials in respect of CD block colorium. This I am showing for the purpose of satisfying
one?
or my lord. Page 30,
Hmm.
there is a table.
Yes.
In the table, the second row is the name of work.
Hmm.
It says supply and procurement of materials in respect of CD block colorium
Yes, yes.
under amending.
Yes, yes.
Now, pursuant to this, I was giving the work order. This agreement I have annexed, letter of intent I have annexed. Page 35 is the letter of intent to address to me, Messrs. C and Travis petitioner by the Director, Rural Development Work. With reference to subject is letter of intent for procurement of material under REGA in respect of CD block Colonial District, Kurumkume. With reference to the tender invited through NIT for above cited subject, Department of So-and-so is pleased to issue a letter of intent for procurement of above mentioned work, including 1.5 years comprehensive guarantee in Kurumkume District, Arunachal Pradesh under so-and-so, having total contract value of rupees 5.775 crore, etc. Next page is the agreement, which is relevant for our case. Lordship, page 36.
Yeah.
Page 36 is an agreement of January 2023. Serial number 2A says that second party shall and will execute the work covered by the items mentioned in the schedule annexed to this agreement at the rate and as per the terms and conditions of this agreement, whatsoever called upon to do so by the engineer in charge within a period of 6 months
Yes.
from the date hereof. Clause D is also important. It says that the second party shall start execution of the item rate items of works mentioned in the schedule annexed to this agreement in 15 days from 31st of January 2024 on the receipt of the letter to this effect from the engineer in charge or from any date fixed in the said letter and shall complete the said work within time fixed by the engineer or as extended by him from time to time. Now, thereafter, I have been supplying in between, and this page 38 is the supply order. Thereafter, I have been supplying. In between, what happened? One of the entities challenged my work order. Page 39 is the order whereby they have challenged. There was unilateral withdrawal, which I challenged. It's a slightly different order, which was allowed. Next page, page 42 is the order whereby there was a stay and ultimately, I'm not reading the whole order. Page 55, also you kindly see, para 27. The interim directions passed by this court earlier on 5/2/24 stands vacated. Interim order that was passed earlier in this case, for which I could not execute the work, was vacated on 5/2/24. As a result, from 5/2/24 to 13/3/20, this order is passed on 13/3/24. We'll find at page 43 is the date of the order, 13th of March 2024. So from 5/2/24 to 13/3/24, I could not execute the work. Then there was general elections for which also I could not execute the work for some time. I have mentioned everything. And in between, there was, because of the rainy season in the monsoon minor, there was a bridge collapse in Kurumkume. All the authorities are aware. There was absolutely total collapse, total stoppage of all activities, for which I filed today. I have subsequently procured some documents Today I filed an additional affidavit, Lordship, a copy is there. Lordship will find in the additional affidavit, I have annexed those relevant documents.
Next, those,
Relevant documents, page 72, running page 72 in the additional affidavit, Lordship will find about the bridge collapse. This is the 1st July 2023, the authority 2024, the district administration issued this order. Lordship has got page 72. Order, Kurung River is flowing heavily and in full speed due to high incessant rainfall, and the water levels are abnormally high. A high rainfall forecast has also been issued by the India Meteorological Department IMD for the next few days in the region, posing threat to the low-lying areas and other vulnerable areas of Koloriang town. Moreover, there has been collapse of Kurung Bridge due to heavy rainfall coupled with multiple blockages on various road points along NH 713 road from Kradadi district boundary to Koloriang headquarters. Additionally, district is facing power and network outages for the past 2 days and is likely to be affected in coming days also. Then they have given the safety numbers, contact numbers of the agencies. Then moreover, to ensure safety of people, properties and livestock, it is expedient to instruct all the denizens and visitors to the Kurung Kumen district to restrict venturing of public into river banks, other flood-prone areas. So because of this, there was the bridge itself was not there. How could I carry materials? Then comes the next page, page 72, Lordship will kindly see. It is learned from reliable sources that some shopkeepers of Neapin town are selling their goods items in an exorbitant rate, taking the advantage of road blocked. Then next page, I have an page 75. In the interest of public, the traffic advisory is hereby directed not to allow heavy vehicles from Pahi Hogu to Kurung Bridge point until the PMGSY road restoration work is completed or further notice. Then page 77, Lordship, I have annexed a order of the authority of 11/11/2024. In respect of all other districts, you will find name of district I have given, extension they have in respect of the district of Tawang. Tawang they have not given there because there is an NIT. And West Coming extension, East Coming, Pakekasang extension is given, Upper Subansiri. Then most of the districts extension has been granted, but in some of the district extension has not been granted. Now, so far as our case is concerned, our problem is that some authorities in the corridors of power, they are somehow interested not to grant extension, for which I have filed this additional affidavit saying that there were real difficulties in execution of the work. In spite of that, show that there was a bridge collapse, there was no connectivity, and then election was there. And then so far as stay order is there is a stay order operated from 5th of February 2024 to 13th February 2024. It's more than 2 months. The entire period that has been given to me is 6 months. Out of that, 2 months have gone because of the stay order. Then there was general election. Then there was bridge collapse. So for all these, I have invoked this particular clause D of the agreement, which is at page 36, which says that extension can be given. Now, when I have filed the representation along with others, they neither considered nor disposed of nor rejected, and now they have come up with a fresh NIT.
yes,
Fresh NIT I have annexed at page
yes. So this was
64.
29,
64.
64.
29 was the first 90% to which I was given the work. Now they have floated a fresh NIT on 29th of October at page
29th of
64.
October.
Yes.
Date and time, is 2011.
And in the table that is there, similar table in the NIT person to which I was awarded, says that in second column, supply and procurement of materials under NREGA 2024-20 in respect of CD block Koloriang, same work. Now, so far as I am concerned, now if the authority is really concerned with the procurement of materials, I want only 1 month is more than enough. Even within 2 weeks I can complete. without giving me extension for 2 weeks and sitting over my representation first one in July 2024.
Now, what about this amount? The one you. which you have completed.
Present value is 4 crore. No, it is 4,34 only. That itself shows how much of work is left out.
It's
4 lakh.
4 crore.
4 crore.
4 crore, 35, 34 lakh. So this is the remaining amount
Yes,
which was given to you.
yes.
What about the amount you have worked, whether they have paid the bills?
I have been paid some amount.
Okay.
How much I have worked? 30% payment we have received and around 60% work we have executed. All the bills are not yet paid. But my submission before Lordship is when I have applied for extension, when the agreement provides a provision for extension, without disposing of, without rejecting my application for extension, they straightway come up with a fresh NIT.
Yes. Yep.
May have.
Hmm.
My lord, may I please come to page 30, my lord, of the writ petition.
30.
Yes, my lord.
Yes.
Yes, this is the first NIT for the financial year 2023 and 24. Now, my lord, the last, my lord, time for completion of work, my lord, 1/8/23 to 31st March 2024, my lord. Now, this is for financial year of 2023 and 24, my lord. Now, we have issued the NIT and we have given them the work. Now, pursuant to that, we have executed one agreement, my lord. That would be page 36, my lord. Again, my lord.
Hmm.
Page 36, my lord. Now, my lord has seen page 30, my lord. It is time for completion of work is 31st March 2024, my lord. Now, my lord, may I please come to page 36, my lord. 36, my lord. This is the agreement, my lord. Agreement, my lord. Clause 2A, my lord. Yeah, my lord. Clause
Yeah.
2A, again, my lord. The petitioners has read, my lord. Again, I will read, my lord. The second party shall and will execute the work covered by the items mentioned in the schedule annexed to this agreement at the rates, my lord, as per the terms and conditions of this agreement, whatsoever called upon to do so by engineer in charge within a period of 6 months from the date hereof, my lord. By this agreement, my lord, we have extended the time, my lord, already, my lord. It was up to
No,
March, my
thi-
lord.
This
As per the
agreement was entered
on 31st January, my lord.
January.
So, my lord, February, March, April, May, June, July, my lord. So they were granted 7 months, 6 months, my lord. So it will start from February to July, my lord. It ends at July, my lord.
No, just see.
Yes, my lord.
D. Page 36.
Page 36, my lord. D is something different, my lord. We have to appreciate, my lord, D, my lord, extending, not extending, it is in the discretion of the authority, my lord.
The
What?
second party shall start execution of items within 15 days from 31st
Yes. Well,
January.
The starting of work, my lord.
Okay.
This is the starting of work.
So that would be, that,
6 months.
that means it will be now 15
Yes, my lord.
February.
Yes, my lord. So, my lord, that's why, my lord,
It will count from February only.
yes, my lord, February. Yes, sir. My lord, this 31st January 2024 agreement was entered, my lord, for the period of 6 months, my lord. 2A says, my lord, for the period of 6 months, my lord. It ends at July, my lord. So, we have already passed the NIT, my lord, the clauses of NIT says, my lord, only for March, my lord. We have granted till July, my lord.
Where do we find that till July?
My lord, sorry, till July, my lord, this 2A will suffice, my lord. 2A says, my lord, may I again read, my lord. The
Yes.
last portion, 2A last portion. To do so by the engineer in charge within a period of 6 months from the date hereof, my lord. Date hereof means, my lord, 31st January is the date of execution of this agreement. Now, from 31st January to 6 months, my lord, we have given 6 months, my lord. From February, my lord, February, March, April, May, June, July, my lord. then it would be
Execution will start from
15
15
months.
days after 31st
January,
That
yes,
is,
ma'am. It will start
15
from-
15
yes.
February, 15 February.
Yes, ma'am. Yes, ma'am. So
it
till
goes up-
15
goes
July,
up to
ma'am.
August.
For 6 months, yes, ma'am. For 6 months, ma'am.
August 15.
I would say July 15 month. Anyhow, Malad. So, Malad, we have already extended, we have given them the time. Malad. Now, what is our wrong, Malad? Page 64, Malad. Whether we have committed any illegality, Malad, that has to be seen, Malad. Whether we were biased, Malad.
The petitioner has prayed for extension,
Yes, Malad.
whether you have disposed of the application.
No, Malad.
Okay.
That for that I have to seek instruction, Malad. What I am saying, Malad, we have issued the NIT, Malad.
Hmm.
So we are in the process of NIT, Malad.
Now, in respect of other, as we have seen that we have extended,
Malad. Well, it is, Malad, the project director has to make the recommendation, Malad. We have not received with any recommendation by the project director, Malad. On the recommendation of the project director, my lord has seen, my lord, page 36, the agreement, my lord. The agreement, my lord, page 36, my lord, clause D, my lord. 2D, my lord.
yes,
That the second party shall start execution of items so and so in the schedule mentioned this agreement within 15 days from 31st January to the on receipt of a letter to the effect from the engineer in charge or from any date fixed in the aforesaid letter and shall complete the said work within the period of time fixed by the officer in charge or extended by him from time to time, Malad. The extension has been, Malad, referred to engineer, but actually it is the project director who recommends, Malad, for extension, Malad. Now we have not received with any extension, Malad, request by the project director. Unless we receive any request for extension, we cannot grant extension, Malad, automatically, Malad.
Well, I have one submission to make.
Hmm.
My learned friend, by referring to the agreement, is saying there is already an extension. Well, I'm unable to understand. The agreement has been executed on 31st January, and agreement itself says that work has to be started within 15 days from thereafter. As your lordship has pointed out, at least from 15th of February, I have to start the work.
is up to 15 August.
Yes, this is one. So there is no extension by the agreement itself. My learned friend is saying, by referring to the dates mentioned in the tender, of that it's 23, 24, etc., that there is already extension. There is absolutely incorrect. There is no extension by the agreement itself. Agreement says, I have given you the work, now you have to start the work from 15th of February. This is number one. Secondly, my lord, when there is a clause for extension, it says that within the time frame or as extended by him from time to time. What is the meaning of this, my lord? Meaning is, in case a situation arises where genuinely a party, a contractor is in need of extension and he applies, the authority will consider and pass an order whether the extension is to be granted or not. It has these words of that extent as extended by him from time to time are not used here without any purpose. There is a purpose. If there is a genuine reason for which extension is to be given, it is to be given. That is the reason. Otherwise, even if someone prays for it, no extension can be given. Now, here is a case. I have raised three issues. One, there was flood and breach collapse. To that, my land has got nothing to dispute because there are government documents. And in other cases, people come with a petition by making a statement. I have made a statement. Apart from this, to support the statement, I have produced government documents which says caution the people not to make any move because of the problem. This is number one. Secondly, my lord, lordship, may kindly have a look just for a moment, page 12, my lord. At page 12, by annexing an order, copy of the order passed by this honorable court, where there was a challenge to my work order, there was a stay order. Page 12, my lord, at para 9, I stated, my lord, that in the meanwhile, an unsuccessful bidder had challenged the letter of intent issued in favor of the petitioner by filing WPC 50 AP of 2024. The said unsuccessful bidder was able to obtain an interim order of stay from this honorable court on 5/2/2024 by suppressing all relevant and material facts. The petitioner, having come to know of the same, appeared in the writ petition and placed all relevant and materials before the Honorable Court. The Honorable Court Honorable Court taking dismiss the said petition by judgment and order dated 13/3/2024. However, since there was a stay from 5/2/2024 to 13/3/2024, the petitioner was unable to make supplies during the said period. So it's more than 2 months. What will happen to this, my lord? I am not responsible for this. It is the person who filed this petition and the respondent authorities who could not resist the interim order in that case. And it was the
even after,
my lord.
even after deducting this 1 month,
Yes,
7 days,
yes.
then it has to be September. You are supposed to.
My lord, here I will say, I'll respectfully submit, my lord. It was the duty of the respondent or the department in that case to point out that in the month of January, there is already an agreement with one party. Without impleading him, don't pass any interim order. You were a party in that case? In that case, you were a party? No. So without hearing him, interim order was passed. They could not resist. And for 5/2 to 13/3, 5/3, more than 1 month. Then, my lord, Lordship may kindly have a look at page 57 for a moment. I'll conclude my submission, my lord. Page 57 is the letter written by all JPM. They are all in favor of extension because they are the persons who are working on the ground. Supplies have to be made through them. And ZPM, my lord, Lordship may kindly see 1, 2, 3, 4, 5, 6, 7, 8, 9 persons have written to the project director. Now, my landlord is saying project director has not done anything. Lordship may ask the project director to come to the court to satisfy this court that even after this representation from 5 ZPM, who has written like this, my lord, with most respect, page 57, my lord, I am reading, it is known to you that MNREGA tender for the financial year 23-24 has expired, and it is also known to you that due to natural calamity, condition of road, etc., it is not conducive for any smooth working within the Kurumkume district. On seeing the condition and situation of time, Jila Parishad members of entire Kurumkume district want to extend the year's farm to carry out the non-wages MNREGA tender till the new tender is floated. We therefore request your competent authority to allow the existing farms to continue carry on the MNREGA work of Kurumkume district till new tender is floated. And this was done in July 2024. They have set over it. By this time, my lord, had the extension been granted, the work would have been completed. And I am saying today, my lord, on instruction that he needs only 2 weeks time to complete the remaining supplies.
Now, what happened in the meantime? So prior to issuance or after issuance, whether your supply continues? No.
No.
When it is?
Well, I have made a statement. We wanted to supply, they refused to take. Where is that statement?
Okay. Since when? Since when?
Since after expiry of 6 months. No? Since when?
According to you, 6 months expired. When the 6 months expired?
Well, I have made a statement. There are 13 possible, and I have made a statement.
There is expired.
My lord.
There are 12.
There are 13.
So this is an extension.
Page 15, my lord.
Come.
Page 15, paragraph 1.
Well, para 13, I have stated, the surprisingly, the respondent authorities did not even consider the application for extension submitted by the petitioner. To the further surprise of the petitioner, the respondents refused to accept the supplies made by the petitioner. Now, this happened in the month of July, my lord. After that, had they granted, if they are interested in supplies, they could have got at the earlier rate from me. They will give it a new rate, higher price, and so for a time.
When they refuse?
Well, I have mentioned
The last supply you did.
well, first representation I submitted in July. That means from July onward, they have not allowed me. Page 57, 9th July. It is very unfortunate that the local authorities, these ZPMs, they are the persons, they write directly to the project director, and project director keeps quiet, and today there is a new tender. And it happened in the month of July, 9th of July 2024. Thereafter also, my lord, repeatedly we have submitted. Thereafter, then 30th July we submitted next page. And it happened to all the other contractors like me. Page 57, 58, 59, lots of me. Kindly have a look. 58, I have given another representation on 30th July, and with all the other, I am not the only person affected, my lord. Others are also equally affected. There are 9 such enterprises.
May I pray, my lord, can it be listed on 20 that entire matter can be disposed of? Because we are not ready for any interim. Because due to the interim, my lord, what happened, my lord? The matter goes delayed and the work does not get executed, my lord. So on 20, my lord, this month, and entire can be disposed of. I will come with the instruction or written instruction, anything. 20,
Mr. Lee Majumdar, Thane Senior Counsel. As we said back, counsel for the petitioner. I've also heard Mr. Winter Picha appearing on behalf of
all the respondents.
all the respondents. Start. Parrot. The petitioner is the successful bidder for supply and procurement of materials under MG Narega 2023 and this 24 in respect of CD block Kolorian Kama, Kurung Kume district, Arunachal Pradesh, within bracket. Stop. The contract agreement between the petitioner and respondent was executed on 31/1/2024. And the supply order was issued on 31/1/2024. Just a minute. Executed and the supply order was also issued. Same there. Executed on 31/1/2024. Stop. On which date the supply order was also issued. Stop. Supply was to be completed within a period of 6 months. However, the supply to be made by the petitioner was delayed. So according to the petitioner, the delay was caused due to the code of conduct in the state on account of the Lok Sabha and Assembly election that were held in the month of April 2024. And it was also caused due to the incessant rain and due to the road blockage caused due to the incessant rain in the district. Stop. it is submitted that there is a provision for extension of extension, and accordingly, the petitioner made an application for extension of time for completion of the work. However, the same has not been attended to. And instead, the respondent has issued impugned NIT dated by an impugned NIT dated 29/10/2024 for supply and procurement of material under MG Narega 2024-25 in respect of CD block Kalorian from Kurungkung district, Arunachal Pradesh. This is package 9. It was package. The earlier was package.
Package number earlier one is 6 and 4.
This is
4.
package 9.
Package 9.
This is package 9.
This is not different.
No, same. When work is same area, same work. Only package name they have given different. Absolutely
Stop.
same.
Page 64. Package 9.
CD
According-
block is the
stop.
main thing.
According to the petitioner, the supply which were to be made by the petitioner in terms of the agreement dated 31/1/2024 are also included in the instant impugned NIT dated 29/10/2024. Hence, by filing this petition, the petitioner prays for setting aside and passing off the impugned NIT dated 29/10/2024. Stop. Back. If you notice, since Mr. Pinto appeared and accepted notice on behalf of all the respondents, no formal notice need be issued. However, the petitioner serve extra requisite copy to the land council for the respondent staff. That Mr. Pinto prays for some time to obtain necessary instruction from necessary instruction. And prays for fixing this matter on 28/11/2024, to which the land council for petition has no objection. No objection. Stop. Stop. 20. Para.
We pray that Lordship may kindly in the interim direct not to proceed, because once now, till now, my instruction is no tender has been submitted. Once tenders are submitted, then third party interest will be created, then they will say that.
Will only say that the finalization.
Yes, 27th Lordship may fix for final disposal, but in the meantime, they should not proceed. Because once they proceed and tenders come in, Then third parties will come and say that we have submitted our tender, kindly hear us, then the thing will further extend, my lord.
Having heard for the land council for the parties, it is. I have provided that. In the meantime, let's see. The respondent shall not finalize. Finalize the,
Lordship may, subject to, lordship desire, lordship may say that they should not proceed with the tender. Otherwise, if they proceed,
no,
they will receive tender.
that may not be possible. Finalization, we can say that. Without.
I understand, my lord, in other case, here,
Or leave of court. They shall
Yes.
not finalize without the leave of court.
that is there, man. But what will happen, third parties, when they submit tender,
Hmm.
they will come and say they kindly impede us, we also want to oppose, then there will be extension. The matter can be disposed of at an early stage. But at this stage, if your lordships ask them to stop, so that on the next day it can be finally disposed of whether extension or not. In that case, my lord, if your lordship ultimately is satisfied and desires to give an extension of 7 days or maybe 2 weeks,
This is matter 120, huh? Till then, the respondent shall not finalize the not the tender process without the leave of this court. That would be right. Okay,
let it be on 27th, man. I've talked to you. 27.
27.
Man.
Okay. Is it okay? 27.
Okay,
Deep level.
problem. My lord.
Yes.
I am in occupation of land measuring 100 square meter, 108 meter. At my lord, Chandranagar, Itanagar.
Hmm.
Now what happened, my lord? This superintendent of police, my lord, has issued SOCOS notice, my lord, and initiated eviction proceeding against me, my lord. Now, I have already filed one writ petition, my lord, which is pending, my lord. In that writ petition, I have challenged, and in this writ petition also, I have challenged, my lord.
You have already filed writ petition.
There is a subsequent development.
This is subsequent development only. What
Yes,
you have
yes.
filed is another writ petition.
Well, for subsequent
filed-
development, no, by way of
Filed
miss,
by way of additional affidavit. It's a subsequent development in that case.
by
only.
way of miss case, well, there is a judgment of our honorable court, my lord.
Hmm.
By way of miss case, impugn order cannot be challenged, my lord.
You are in the impugn order.
Subsequent order, yes, subsequent
You
impugn
are
order.
challenging the subsequent order.
Yes, my lord. What happened, my lord? My lord may see, my lord.
No, this subsequent order was passed when the order was passed by this court. After
Uh,
that,
Or on the same date.
on the same date.
Yes, my lord.
Then the order must have probably did not reach on time.
My lord, we have
And then
furnished the
after
copy.
passing of the subsequent impugn order,
My lord.
probably the order reach.
Yes,
Because order you get in the evening. And if the or subsequent, the impugn order probably was passed at the daytime,
my lord. My
prior
lord,
to passing of the order.
yes, my lord. My lord, may please come to page 41, my lord. Page 41. This is the interim order, my lord, passed by this honorable court, my lord.
Page-
It's protected. Yes, my lord. Page 41. Status quo order was passed, my lord.
But then this status quo order did not reach on the day, on the
Yes, sir.
same day, because on the same day it was passed, it appeared.
Yes, there might be
20.
some miscommunication, or because of that, I have to file this writ petition, my lord, challenging the subsequent, my lord, development, my lord. This is the subsequent impugn order, which is not the part of my first writ petition, my lord.
Where is the subsequent impugn?
Page 44, my lord, page 44. I have been directed to evict. Same
Whether,
date, my lord.
whether under section 7(1) has already been invoked thereafter. It only says
Yes, ma'am.
you directing you to remove the erected boundary wall and the residential building
Yes, my lord.
from
Yes,
the
ma'am.
said
My lord,
premises.
I am challenging the.
On or before 7(7).
Yes, my lord. No, it has not been executed, my lord. But I have
No,
to.
no, you were directed to. do
Yes,
that.
yes, sir. But they have
Remove the
not
erected-
initiated, my lord.
Hmm? You
They
did
have,
not do. You
no,
did-
no,
You did not comply.
no, because there is a, my lord, interim order, my lord.
No, no, not
Operating.
this. This, you said that this
But
is
on the
subsequent-
on the same issue, my lord, interim has been passed, my lord. On the same issue, my lord. This is only the subsequent development. Because of that, after, my lord, this interim order was received on the same date, 36/23, my lord. Might be
Whether,
they,
whether the authority did anything after
no,
the
no,
passing of this.
nothing, my lord, nothing.
Okay, and then they also did not issue against you under section 7(1).
My lord. Nothing has been done, my lord.
To say that 7(1) shall be invoked
Yes, my lord. Nothing has been done.
in case of your failure.
Yes,
Nothing has been done.
due to the interim protection given by this honorable court, my lord.
Hmm.
Yes, my lord. Its status quo, my lord, order has been passed, my lord, in the other writ petition.
Whether in that writ petition, the petitioner, sorry, the respondent has filed any affidavit.
Well, they have filed affidavit in opposition. That is the interesting part, my lord. They,
And
Well,
have they incorporated this one, this order, impugn order?
yes, your honor. From that I have collected one.
Okay,
From their affidavit in opposition, I have collected this document and I have filed this writ petition, my lord. My lord, because I was
What
not
is your
furnished with
prayer
this.
here? What is your prayer here?
My lord, to stay, my lord. Only the new prayer is, my lord, for quashing of this last, my lord, the subsequent development. Otherwise, the all prayer are same, my lord. Only the new prayer has been added, my lord. 36/2023, my lord, maybe cost, my lord. And I'm also praying for this stay of this order.
Yes, sir.
Notice may be issued. And whether it listed along with this resolution number
Yeah, it has to be listed
343.
along.
Next week it may be listed.
Okay, what about the stay? This impugn order has not been stayed, but then of course the status quo order has been
The
passed.
status, it will cover this order also. The
Okay.
status means is as to the positions of the lay.
Right, and according to him, the authority also did not do thereafter, and did not do anything thereafter after that.
No, nothing has been done.
Okay.
My lord, I have made
This
one.
present impugn order, it was passed on the same day when the matter was
Yes,
moved
yes,
before
yes,
this.
that is why I'm saying.
Yes.
So,
So, since the matter is sub judice before this whole court, so we are just doing nothing.
okay.
Even by this status quo order, interim order, even the petitioner has been directed not to make any concession.
We have not
Yes.
done anything. my lord.
Yes, yes.
Now, my lord, I have
So-
made one allegation, my lord. In their
Yes.
affidavit in opposition, my lord, the SP has come with an affidavit, my lord, affidavit in opposition, saying that they were given the land allotment in the year 1986, my lord. Now, what happened in the year 1986, 26 November 1986, the land allotment was given to the police department. They claim, my lord. Now, they come with an affidavit, or they come with a map, my lord, of 15/9/23 after filing of the writ petition. 36/2023, my lord, interim was granted, my lord, in the motion interim. Now, my lord, on 15/9/23, my lord, they manufactured a document, my lord. They manufactured one map, my lord, and come with it. My lord, by way of map, a land can be ascertained, my lord. Let's say an example, my lord. I have one land, my lord. Government has given me one land at Nahalagan, my lord. How can I identify, my lord? By a map, my lord. No, please, page 51, my lord, see, my lord, page 51. They have manufactured one map and only indicated my plot of land, my lord. Only my plot of land. Nowhere their plot of land has been, my lord, indicated, and it has been generated on 15/9/23, my lord. Page 51, my lord. 51, my
The
lord.
government manufacturing.
Yes, my lord.
document to trust.
Yes, my
That may
lord.
not be possible.
And there are so many lies, my lord.
Anyway, that merit may be hard on the day of hearing.
Okay.
Upstream.
May I propose one thing? Here, even the notice may not be required. This matter may be listed along with that particular writ petition.
Yes,
Because
that
in
will be
that
better.
writ-
That will be better.
in that
Because
writ-
notice already.
My lord, I have
Because-
made some allegation, my lord.
Yes.
If they do not file any affidavit, my lord, because I have made some personal allegation, my lord, against the SPN. If they are not going to file any affidavit, it is presumed they will be admitting. my lord. Yes. Yes, let them file, my lord, because they are saying they won't be filing, my lord. If they won't be filing, they are admitting.
Here, they are challenging the present impugn order, which is a subsequent development.
Yes.
And probably here also, you may have
May.
to file affidavit.
Yes, my lord.
Here, more or
Because
less,
in that case, this was not there.
And the map was also not there. By way of that affidavit
Then-
opposition,
then
I
the
collected this
notice
map
may be
also.
issued.
Yes. Mr. Bindu Piche, Learned Counsel for the petition. Okay. I've also had Mr. Tapi, Learned Counsel appearing on behalf of
I'm for one and two.
respondent number 1 and 2. And,
I'm for three.
and Mr.
Zero.
Dolan. So the respondent appearing on behalf of the respondent number 3. Okay. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 26/6, not 26, 30,
30, my lord.
30,
Yes, no. 36/23.
6, 2023, issued by the respondent number 3. Directing the petitioner to remove the erected boundary wall and the residential building from the from the premises occupied by the petitioner on or before 7/7/2023 without fail. And in case of with the further order that in case of this failure to comply with the said order, Section 7, within bracket I, bracket 4, shall be invoked, and necessary demolition of the above mentioned, demolition of the boundary erected by the petitioner. The boundary wall and the residential building erected by the petitioner shall be carried out on 8/7/2023. It is submitted that the petitioner earlier has filed a writ petition. Where is the writ petition?
My lord, my prayer, my lord.
Hmm?
My prayer, my lord.
Page?
Page 24, my prayer, my lord. Interim
No,
prayer
no,
would be
no,
page
the
24.
writ petition, earlier writ petition,
Earlier it- Yes, my lord. Page 41, my lord.
filed writ petition.
41, my lord.
Hmm. Being registered as WPC 314/2023, challenging challenging the so-called notice dated 16/6/2023 and 26/6/2023 issued by the respondent number 3. And this is the subsequent development. None. Just a minute. Received. And by an order dated 30/6/2023, this court while issuing notice upon respondent has passed an order for maintaining status lane in question. Pass an order to maintain a status quo in respect of the lane in question. And also directed the petitioner not to carry out any kind of construction over the said land. But issue notice returnable by 4 weeks. So since Mr. Tapin has accepted notice on behalf of the respondent number
1 and 2.
1 and 2 and Mr. Lauren for respondent number 3, no formal notice need be issued to the said respondent to stop. However, the petitioner shall furnish extra copies of the petition to the District Council appearing on behalf of the respondents during the course of the hearing. Since the okay, we'll say
Now, this impugn order may be stayed.
since this writ petition arising out of the writ petition number.
Yes, my lord.
Okay. Writ petition number,
314
okay, 314.
of 23.
23. The matter may be listed. This matter may be listed along with the said writ petition. Okay,
My lord.
list after 4 weeks.
After a week.
After a week,
Because it may not be necessary to file it.
okay.
My lord, the number 3 has to file, my lord, because I have made
Then
some
issue
personal
is
remarks.
Returnable by.
3 weeks, 4
Okay,
weeks.
after a week, huh? 4 weeks.
After a week.
After a week.
Yes.
Okay.
Ma, obviously.
Please, Your Honor.
Yes,
One of this writ petition has been preferred by the petitioners challenging the transfer order dated 19 September 2024. Your Honor will find the order at page 18 of the petition. At page 19, Your Honor will see that the
Page 19?
petitioners. Yes, Your Honor.
impugn order.
Relevant pages at page 19 where the petitioners' names have been mentioned. At serial number 43, 44, 45, 46, and 47.
43,
44, 45, 46, 47. So these are the petitioners.
these are the writ petitioner.
Yes, Your Honor.
They have been transferred from,
They've been, for serial number 43, petitioner number 1 has been transferred from GUPS ALC line Tooting to Daporijo.
different place,
Different places.
different places.
All of them have been transferred in different places. The main contention of the petitioners is that, Your Honor, this transfer has been passed in violation of the transfer and posting guidelines that has been published by the Education Department itself. According to that, all transfers should be made only once in a year, and all transfer cases should be disposed of by the month of May. But in this case, this transfer order has come out in the month of September and signed by the authority in the month of October, 10th October. And only in emergencies where there are administrative exigencies or in the interest of public, can be made all year round.
How long you have been in the present place?
Pardon, Your Honor.
How long you have been in the present place?
That is not under dispute, Your Honor. They have been serving in this place for
Only
considerable
that
amount
it
of
has to
time.
be issued in the month of May.
Yes,
Only your contention,
yes, Your Honor.
not now.
And even if the transfers are made, it should be if there are any administrative exigencies or in the interest of public. However, if Your Honor will go through the transfer order, there's no such reason that has been mentioned by the authorities while passing of this order. And there are similar matters which are for this honorable court.
What matter? Similar.
Similar matters arising
Okay.
out of the same transfer order where other petitioners have approached this honorable court. And in those cases, this honorable court has granted interim relief to the petitioners by staying the transfer order. So I beg to also submit those orders for this honorable court. Thanks today, Your Honor. My prayer is that notice may be issued and my interim prayer may be granted by staying the transfer order.
Are you also alleging that it was based on the political consideration?
That, yes, Your Honor, but
Here in this
however-
case,
However, in this case, we do not have any document. In other cases, there were some recommendations from the MLA. But in this particular case, there is no such thing. But then it is arising out of the same transfer order.
Yes, Mr. Tugong.
My lord, arising out of same transfer order, my lord, we are sought for, in other case, we sought for Paraguay's comment, my lord. We yet to receive, my lord.
Mm.
In that case, we'll file a counter detailed affidavit in this case, whether there's an administrative exigency or not. Only on perusal of the records and the instruction department only we can say, my lord. Since it is connected, my lord, may I pray, my lord, this can be taken together the other writ petition, my lord.
This is connected, arising out of.
Out of same,
transfer order.
my lord. In other petition, we are sought for Paraguay's comment from department.
By this order, okay, so,
Page 18. now.
yes. So these all came, all are
Same
arising
transfer,
out of the.
same
okay.
transfer.
Okay. R. Ms. T.Y. Bhutia, National Council for the Petitioner. Also R. Mr. T. W. National Training Council, Education Department. Preparing for the respondent number 1, 2,
4, my lord.
4. Para. How many petitioners here?
There are total 4 petitions.
Five.
Five petitions.
5. Oh, this is an application filed on the section under Article 226 of the bill, challenging the legality and validity of the transfer or the by the transfer order dated 19 September, it's same. Yes,
19 September 2020.
transfer order by memo number Elementary Education Department 10212 within bracket 11 bracket close stroke 8 stroke 2024 dated 9/2021 signed on 10/10/2024 issued by the Commissioner.
Commissioner Education.
Commissioner Education, Government of Arunachal Pradesh, whereby the petitioners who is petitioner number 1?
At serial number 43 on page number 19.
43 is 1,
43
44 is 2.
petition number 1.
serially. Whereby the petitioner number 1,
Yes, Your Honor, serial.
Shri Pemas Samten, TGT has been transferred from, what is this GUPS?
Government Upper Primary School.
Okay, from Government Upper Primary School, ALC line, Tooting to
Daporejo.
which district? Daporejo, at the disposal of DDSE Daporejo. Semicolon. Petitioner number 3, Tasiseri, TGT, from GUPS Gailing to Daporejo at the disposal of the DDSC Daporejo. Petition number 3,
Palden Sang.
Palden Sri Palden Salingpa. Here, comma PRT from GUPS, comma Gailing to Basar at the disposal of DDSC Basar. Petitioner number 4, Sri Nima Lama. PRT from GPS Kopu to Daporejo at the disposal of BDSC and Rinchin petitioner number 5, Rinchin Dorji, PRT from GPS Pekong to Likavali at the disposal of DDSC Likavali. It is submitted that the present transfer order has been made in the mid-academic session in violation of the transfer policy of the Department of. Have you annexed the transfer policy?
Pardon me, Your Honor?
Have you annexed the transfer policy?
Yes, yes, Your Honor, I have.
Page
Yes, I
26
see.
onward.
In violation of the Teachers Transfer and Posting Policy 2019 stroke and sorry, dash to 2020 within bracket education. It's a violation of especially which
Of clause 8 on page 29,
clause 8.
transfer calendar. According to this, Your Honor will see at serial number F, 16th May to 31st May, disposal of all transfer related cases and process completion.
Okay, yes, yes. Especially the clause 8 of the same application dated 10 to 2020 issued by the government of Arunachal Pradesh. Stop. Issue notice returnable by 4 weeks.
4 weeks.
Stop. Since Mr. Progom appeared and accepted notice on behalf of all the respondent.
Yes,
Oh,
yes,
okay.
yes.
No formal notice need be issued. Mr. Progom further submits that the similar matter arising out of the same transfer order is pending before this court, in which the respondent is filing affidavit.
Has to file, man, yet to file, man.
He is yet to file affidavit and pray for listing this matter along with
Along with those, man.
those, what are those? Give
I'll,
number,
I'll furnish, man. We have
along
to
with those
work out.
WPC, along with those writ petition stuff. Writ petition being WPC.
Madam, yes, that will have to
Okay.
furnish, madam. We'll to collect that number, madam. Yes.
Is this the one?
That is,
The ones that I submitted, they are the ones, plus there are some more other cases.
There. One, which one?
All three of them.
3 of them.
if it is connected, madam, it will automatically take together, madam. In other cases, it has been take, madam.
Okay.
If it is once take, madam, here in particular, one or
Then
two
we
cases.
mention this,
Madam, madam, madam.
this is not yet been disposed.
Yes, madam, not yet.
Okay. connected with WPC 5/10/2024, WPC 4/6/2024, and 4/7/2024. This is matter. Along with the above, this is matter. Along with the above writ petition, along with the above mentioned writ petition
After 3 weeks.
after 3 weeks.
Interim prayer month. Will be stated in
Okay,
the
till
law.
then. Till in the interim it is provided that till the refundable date, the operation of the impugn order dated
19th
So,
September 2024.
what is your prayer is not to release or
Transfer may be stayed, Your Honor, in respect of the current petitioners.
the impugn transfer order dated 19/9/2024 in respect of the petitioner in respect of the above 5 petitioners. Shall remain still.
Keep your motion.
Yes.
My lord, petitioner's land measuring 50,000 square meter, my lord, is under occupation of border organization, my lord, since 1978. Which
Petitioner
was
is?
Huh?
Oh.
Which was initially allowed by petitioner's late father temporary for establishment of a camp, grip camp for keeping men and machinery during the construction of after completion of road, my lord, this land has not been returned. For that, my lord, petitioner has filed various representations before authority, my lord, either to vacate border road from petitioner's land or acquire it through acquisition process. In the meantime, my lord, land acquisition notification was issued, my lord, which is in Annexer 3, my lord, page 44-45. Sorry, my lord, it's in page 42, man. 41, 42, 40, 41. Page 40, 41, man. Land acquisition, man.
Page
40, man.
40,
Yes, man.
then acquisition.
Yes, man. By this acquisition, my lord, out of 50,000 square meter, my lord, 1,100 square meter was acquired, my lord, for this frontier road, my lord. So, my lord, there is now remaining 44,999 approximately, my lord, square meter of land, my lord. So, my lord, I have filed representation, my lord.
For this, for acquiring this, any compensation paid?
Yes, my lord, here, my lord, award was passed, my lord. Award is in,
No, for acquiring this 5,001,
yes,
any compensation paid, awarded
yes, my lord, award has been passed, my lord.
to whom, against whom? To whom the award was given?
My lord, here, my lord, award, my lord, for components, my lord, standing asset, my lord.
structures, my lord,
It was given to whom?
to border road, my lord.
Not to you.
Yes, my lord. For that, I
The
have filed
border road is the owner,
No, no, my lord. Land has been given to me.
given to you, but
Yeah.
then the compensation was paid to BRO.
Not yet paid, my lord. For that, I have filed writ petition. Before
You want the compensation to be paid to you.
Yes, yes.
Why?
No, my lord. This is that, my lord. I have for that, my lord, I have filed another writ petition, my lord,
Another is petition for what?
for not preferring compensation for standing structures in my favor, my lord.
Not
Preferring compensation estimate, my lord. Compensation, my lord, for standing structures.
for non-preparing.
Yes, my lord. By ever was passed, my lord. But for standing asset, compensation was not prepared in my favor, my lord. It was prepared in favor of border road, my lord. That's why I filed writ petition by
What order was passed in that petition?
in
Only
the
notice has been
no, no, my
issued.
lord. In the interim, my lord, it was directed to respondent authorities not to release compensation in favor of border road, my lord.
That
Till,
has-
till disposal of the writ petition, that writ petition.
That is with regards to the same land.
Same length, that is regard to 5,001 square meter,
Okay,
which was equipped
and
with
this-
road boarded.
This
This is for remaining land, my lord. I have,
44,000.
yes, my lord. I have, my prayer is, my lord, either acquire this land or return it to me, return back it to me so that I can repossess it. Because this is my land, there is no doubt, my lord.
Acquire is to be done by whom?
By Deputy Commissioner for the border roads.
Yes.
My lord, notice may be issued.
We should, I'm referring for respondent three, my lord, for deputy commissioner, my lord.
You are Mr.
El Nusin.
L.
Nosi.
Nochi. Nochi. Land council for the petition. for vacating the border road, vacating the respondent 3 and 4. Sorry, 4 and 5 from the said land. And further to return the remaining land. What is this remaining land? Why remaining land? Not all.
Out of 5,100
Okay.
square meter was acquired for land.
Okay, land measuring 44, remaining land measuring 44,999 square meter. Located at only Lower Dibang Valley district, Arunachal Pradesh, to the petitioner. Are you also praying for compensation?
Yes, my lord. Either to vacate the land or to acquire the same under appropriate law.
Okay, stop. There. Issue notice returnable by 4 weeks. Miss, you are for respondent number?
3.
I am for respondent number 1 and 2.
You are for 1 and 2.
Yes, ma'am.
Okay. Okay, accepted, Dugma. Has accepted notice, appeared and accepted notice on behalf of the respondent number 1 and 2. And Miss Wang for respondent number 3. No formal notice need be issued to the said respondents. However, the petitioner shall furnish extra requisite copy to the land council for the respondents during the course of the day's start. The petitioner shall take steps upon the respondent number 4 and 5 by a registered post with AD within a week.
May, my lord, I have already served the copy to Mr. Kato, my lord. DSG, my lord. Marco Kato, my lord.
Marco Kato?
Yes, I have already served the copy, my lord.
Okay.
I'll
On
furnish
behalf
extra
of
copy to him.
both the respondent number 4 and 5,
Yes, my lord.
he is not appearing despite of receipt of the copy.
Yes, my lord. I'll furnish him extra copy also, my lord.
Okay. The land council for the petitioner submits that he has already furnished, and he has already supplied a copy of the writ petition to the Marco Kato. He is what was his designation?
DSGI.
DSGI
GI.
on behalf on behalf of the respondent number 4 and 5. The petitioner shall furnish extra copy to the landed DSGI within 3 days from today. Start. Okay. List this matter after 4 weeks. Okay.
Okay. Obliged, ma'am.
May I crave your lordship indulgence?
Yes.
May I crave your lordship indulgence? I think item number 20 and 23 was mentioned in the morning, my lord. There was no internet connection of this honorable court, so I was there, but I could not connect it. So I think only my name may be recorded, my lord, BK Singh for Food Corporation of India.
Okay.
In item 20 to 23.
20 to 23.
Yes, my lord.
Okay. Mention was made this morning. So only record Mr.
BK Singh.
BK Singh, Land Council for
BK Singh.
BK Singh, Land Council for a petitioner is also present. Only that. Okay.
My lord, also another item number 29, I have taken consent from the opposite side, my lord. It's a hearing matter. May this matter be taken up after 3 weeks, my lord.
Okay. Then item 29.
29, my lord.
Mr. BK Singh, Land Council for the petitioner, with the consent of the other side, prays for listing this matter after 3 weeks. The prayer is allowed to list this matter after 3 weeks. Okay. So
Highly
the
obliged, ma'am.
rest of the matter at 2. Yes. Hmm?
May I please, Your Lordship? Lordship, in this matter also, I'm challenging the interim transfer order, Lordship. Your Lordship will find it page number 33, Lordship. In fact, Lordship,
This is also same impugn order.
same impugn order, but the ground I have stated that's different, Lordship. Because since I am a cancer patient, Lordship, the first transfer which was I was posted at the Dapurjo BN colony, Lordship, it was on a medical ground, Lordship. And after serving one year and 3 months, that again this transfer order has been passed by violating the different clauses of the policy guidelines, Lordship. Similar order may be passed, Lordship. In the meantime, notice may be issued and stay may be granted, Lordship. Yes. That item number 10, Lordship.
Item 10,
Yes, Lordship. The wherein your Lordship has passed an order today itself, Lordship.
stay.
Stay, Lordship. That order may be passed, Lordship. Because later on, Lordship, when the hearing will took place, that my ground will be different from the other petitioner who approached this honorable court earlier than me, Lordship. Your Lordship will find my name at serial number 62, Lordship. That impugn order page number 33, Lordship. Page number 60, page number 62, serial number, Lordship. Yes, 62 serial. That is Talam Singh name.
And then you have also submitted representation there.
Yes, Lordship. As per the Lordship, in fact, as per the clause 10 subclause C plus 1, Lordship, my representation, after submitting of the representation, Lordship, the department has to recommend the representation to the medical board, Lordship, whether I'm diagnosed with the cancer or not, since I have annexed all the medical documents, Lordship.
This has to be, your case is to be forwarded to medical.
A medical board, Lordship.
board
But
by
Lordship,
whom?
by the department concerned, Lordship.
Department
Yes,
for
Lordship.
examination.
Yes, Lordship. They have not done and my representation is still not considered, Lordship.
Where is the Lord Council for the Education Department, standing council?
Then in the meantime, then
Mr.
T. Garam, Lordship.
E. Garam,
Lordship.
Lord Council for the petition. Sir. Your challenge is on the basis of your medical or
Yes, Lordship.
is against the scheme? Are you
Yes,
also
Lordship.
challenging the
Yes,
scheme?
Lordship.
Okay. Yes. So. So he's praying for the similar order with item 10. So in the meantime, the impugn order in respect of the petitioner shall be stayed.
That's right, madam.
Yes, yes.
Rising out.
Okay. So it will be same impugn order is also same.
No,
Yours is
yes,
on the
serial number
serial number
62 or page number 33, Lordship. My name will be reflected at serial number 62, Lordship.
62.
Yes, Lordship.
Okay. So
Okay.
this. Similar order. I've also heard Mr. Bogong, that is standing counsel for the education department staff. By filing this application under Article 226 of the Constitution of India, the petitioner has challenged the impugn transfer order dated 19/9/2024. In respect of the petitioner, when issued by the Commissioner of Education, Government of Arunachal Pradesh, whereby the petitioner at serial number 62, Sri Talong Singh Ming, Shama PRP, GUPS. GUPS means
Lordship, the first transfer order, Lordship will find at page
no, it's
number.
okay. GUPS. GUPS means okay, Government Upper Primary School, GUPS. Orak, it's
No,
Orak.
Lordship, it's supposed to be, Lordship, the BN colony, Daporejo, Lordship. Lordship will find page number 33, Lordship. But it has been wrongly reflected as Orak, Lordship.
Your is serial number
Serial number 62, Lordship.
is Talom Singh Ming,
Yes, Lordship, but the.
PRT.
Yes, Lordship, PRT.
It's
PRT,
not from
Orak,
G-
instead
not-
of Orak, Lordship, it's supposed to be BN colony, Daporejo, Lordship.
Now, how do we correct here?
Lordship will find at page number 33, Lordship. Page number 33.
33.
Yes, Lordship. This is the first transfer order, Lordship, where I have been transferred to BN colony, Daporejo, Lordship.
Page 33.
Page 33, Lordship.
It's all the same.
Oh, sorry, Lordship. Sorry,
It's
Lordship. The page number
34 is continuation of 33.
No, Lordship. Page number 31, Lordship. I'm sorry, Lordship. 31.
31 is in the year
This-
2023.
23. This is the first transfer order, Lordship. Lordship will find it serial number 20, Lordship. That is Talam Sangmi, Lordship. PRT, this Orak, Lordship.
It's Orak only.
Yes, Lordship. To BN colony, Daporejo on medical ground, Lordship. Now I have been presently posted at BN colony, Daporejo, Lordship.
Now, not GUPS Orak.
No, Lordship. It was a typical error in the transfer order, Lordship. It is supposed to be BN colony, Daporejo, where I'm posted right now, Lordship. Now my concern is from BN colony, Daporejo, I have been transferred. Lordship will find is page number 33, Lordship. That the serial number 62 is to Tirap district. That is a hard posting, Lordship. My concern is only to relief from the present place of posting to the Tirap district.
GUPS Orak Upper Subansari district within bracket. It will, according to you, it will be
BN colony, Daporejo, Lordship.
BN
Yes, Lordship.
within bracket, huh? Government UPS BN colony, comma Daporijo bracket close
Yes, Lordship.
to GUPS Noglu Tirap district.
Lordship.
On the ground that the petitioner. Just a minute. Stop. Huh? It is submitted that the petitioner was recently transferred from government UPS Orak to
BN colony, Daporejo, Lordship.
government UPS BN colony, Daporijo, by an order dated 10/5/2023 on medical ground. However, stop. Huh? without considering the recent transfer of the petitioner and in violation of the teachers transfer and posting policy 2019-2020 within bracket education, more particularly the notification this, the policy number 7 issued by the government of Arunachal Pradesh from the respondent authority has issued the impure transfer order. Stop. Being agreed, the petitioner has filed this writ petition. And prays for setting aside and quashing of the said impugn order. Stop. Fair. Issue notice returnable by 4 weeks. Since Mr. Togu has appeared and accepted notice on behalf of all the respondents, no formal notice need be issued to the respondents. However, the petitioner shall furnish extra copy of the petition to the Land Council appearing on behalf of the respondent during the course of the case. Stop. List this matter after 4 weeks. Stop. Para. In the interim, till the return of the date, the operation of the impugn order dated 19/9/2024 in respect of the petitioner shall remain stayed.
Deeply obliged.
Yes. What about the 13? John, okay, yes.
My lord, this is a quashing application, and the other side they want to adjourn the matter today, and this matter has been pending since more than 1 year, almost 2 years. So this may be taken up on Monday.
Let's pray for by the Land Council. You are for the petitioner.
I am for the petitioner.
Land Council for the petitioner, Mr. Kambu.
T. Sunil.
Sorry, you are Mr.
T. Sunil.
Sorry, T. Sunil. This matter. Again, on Monday, is it okay? Monday. You are Mr. Land Council for the respondent is also present. Okay. This is matter on Monday accordingly. Okay, much good. Yes.
My lord, this is to bail application, my lord. In fact, on the date of motion itself, my lord, the interim was granted, my lord. In fact, my lord, there was a misunderstanding, my lord. Of course, the allegation made in the FIR, my lord, it is very serious in nature. But then the moment the complainant realizes the misunderstanding, both of them have entered into agreement, my lord, and the matter has been settled outside the court, my lord, immediately after the filing of the FIR, my lord. And therefore, my lord, apart from this bail application, my lord, I have filed one criminal petition for quashing of the FIR itself, my lord, and that is also pending, my lord. My lord, since the interim order was granted to the applicant, my lord, and thereafter, my lord, the
alleged accused, my lord, he has gone to the police station, Basar, and got his statement recorded, my lord. Since everything has been
He
completed,
was shown arrested.
my lord. Yes, he has been shown arrested.
Do you
my
have the record?
My lord, she might be having that.
You have the record?
Lordship record.
He was arrested.
He arrested and he has given his statement also. And whether this is the status report, Lordship. The statements of the victim, complainant, witnesses are there. By, it is also in annex.
Or Mr. D. Kamble, the counsel for the accused applicant. Also had Ms. L. Hage, the additional people, the public prosecutor for the state staff that by an order dated 24/9/2024. While calling for the scanned copy of the case study, this court has granted interim anticipatory bail to the accused petitioner, directing that in the event of his arrest, the accused and go back in connection with in the event of his arrest of the accused, applicant Sri Hango Bam in connection with Basar PS case number 22 of 2024 under section 62/76/331 within bracket 2/331 within bracket 4/351 within bracket 3 of the BNS 2023. He shall be enlarged on interim anticipated interim pre-arrest bail on execution of bail bond of rupees 25,000 with two surety of like amount with certain conditions. Stop. Para. After obtaining the interim anticipated outcome, the accused applicant has appeared before the eye of the case in connection with the above PS case. And on his such appearance, the eye of the case has arrested the accused and thereafter recorded his statement, police statement stuff. And after completion of the such procedure, the accused was released on interim anticipatory bail, released on bail on the strength of the interim anticipatory bail granted to the accused on 24/9/2024 on execution of bail bond of rupees 25,000 with two surety of like amount. Stop. The Lani Council for the Judicial Assembly said since the accused has already been arrested and released on bail, this bail application has become infractious. The Lani Council for the Petition Assembly said that is not necessary to record the agreement. Okay. submit that since the accused has already been arrested and released on bail, this bail application has become infructuous. Hence, pray for regularization of the interim anticipatory bail granted to the accused on 24/9/2024. Miss Lakshmi, Planet Edison PP, while referring to the scanned copy of the plan and the case diary and the status report, has also submitted that after obtaining interim anticipatory bail, the accused has appeared before the eye of the case, and on his such appearance, he was arrested and released on bail on execution of the bail bond as per the interim anticipatory bail, on the strength of the interim anticipatory bail granted to him on 24/9/2024. He has also submitted that since the accused has already been arrested and released on bail, this bail application may dispose of according to staff of Para. Part for the Rani Council for the parties. I have also perused the case study as well as the status report produced by the additional people staff. The record reveals that after obtaining bail, the interim anticipatory bail, the accused has appeared before the eye of the case, and on his appearance, he was arrested. When he was arrested, that must be
It is in the record, Lordship.
Hmm?
When he appeared before the IO for the statement, then he was arrested and released on bail, Lordship.
Okay, no, when
Lordship,
we have any date?
Lordship, it will be in the record, Lordship.
This is too small. This is illegible.
May I, Lordship?
Just a minute. The accusers on his such appearance, the accused was arrested, and after completion of the formalities, the accused was released on bail. And after recording his statement and other formalities, the accused was released on interim anticipatory bail, released on bail on the strength of the interim anticipatory bail granted to him on 24/9/2024. The record also reveals that the case has already been submitted in the charge sheet. In view of the above, and since the accused has already been arrested and released on bail, his bail application has become infructuous. So accordingly, the interim anticipatory bail granted to the accused on 24/9/2024, is hereby regularized and made absolute with the same terms and conditions, with further condition that the accused shall appear before the trial court as and when called for staff. This bail application, this bail order shall be read along with the bail order dated 24/9/2024. Staff, with the above, this bail application stands disposal. Okay.
My lord has recorded that the bail has been made absolute, my lord. Absolute, my lord. Bail has been made absolute, my lord.
Yes, made
It has been recorded, my lord.
Yes,
in the order, my lord.
recorded.
Much obliged.
Yes, Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, on behalf of Mr. Jiriba, leading counsel for the respondent, he is currently out of station. Therefore, this matter may be adjourned for the day. Pleadings are completed.
Even they are not yet filed. It is completed.
Yes, Lordship.
Okay.
It may be
Mr.
listed in admission hearing on next date.
Okay. Mr. Yes, it is complete. Is that for admission hearing? For the next hearing. Okay. Mr. Superintendent, yes, Land Council for the petitioner. Also Mr.
Elteni.
Land Council appearing on behalf of the respondent staff. The Land Council for the party submits that the pleadings are completed and the matter is ready for hearing. Sorry, pleadings are completed. Matter may be listed for admission hearing staff. Okay, list this matter for admission hearing after 2 weeks. 2 weeks. Okay. All right.
Highly obliged.
My lord, I'm for affiliate, my lord. Meta speaks for order.
The book is ready. Yes. It's ready. What about these fresh steps not yet taken?
Your Honor,
Notice upon the respondent number 2.
step has already done. Second.
As per official note, it's not taken. As per office note, it was not taken because this is a POCSO case and it is mandatory to serve the notice to the victim.
Respondent number 2 not appeared. He is a
Yes.
informant or victim. Respondent number 2.
Is an informant.
Yes. Suppose informant.
Informant.
Yes, he is an informant. Does not appear. So you were to take fresh steps upon the respondent number 2.
Yes, step not yet completed.
As per the office note, you have not taken fresh steps. You have to take fresh steps.
Yes, Your Honor. Yes, ma'am.
Take
I
fresh
have
step.
already taken fresh step.
When?
So,
No, the office note reflect the recent that you have not taken fresh step. You were directed to take fresh steps upon the respondent number 2. Yes, by an order dated 27/5.
my lord,
Not yet taken.
my lord, on 27,
You-
5.
You take fresh steps upon the respondent number 2. Okay. Miss, your miss,
Miss T said,
your name is there.
yes, Your Honor.
Okay. E,
T said, SETH.
Land Council for the appellant.
May I pardon? My lord, already taken step, 27, 5, 2024, already taken.
No, on that
Respondent number 2.
Then step taken has to be filed in affidavit form, whether they have really taken step. Office note says otherwise.
I think to ensure you take steps, fresh steps. Okay. One more time. Their appearance is necessary unless they appear it will be difficult to proceed with. Okay. Ms. Six, Land Council for the appellant, prays for some more time to take fresh steps. No, just a minute. In view of the office note dated 13/11/2024, Ms. Harnett prays for allowing her to take fresh steps upon the respondent number 2. The prayer is allowed. Step be taken upon the respondent number 2 through the concern
Jurisdiction, yes.
OC,
Yes, OCPS.
OCPS through registry.
Through registry.
Okay, okay, the concern PS, within a week from today. Okay. Week from today, So you have received a copy of the paper?
Yes. Yes.
Okay. The paper book is ready and the party has received a copy of the same. This is matter after 3 weeks. Oh, where the respondent number 2? What is the address of the respondent number 2? After 3 weeks only?
Yes.
Oh,
It
this
will
is matter after 3 weeks. Okay.
So much.
I please, your lordship. Lordship, I kindly pass over for time being, lordship. My senior is not present now.
This is last matter.
Last orders matter.
What is this matter about?
This is the tender matter, lordship. Otherwise,
Yeah, part of it, my lord. Then, NIT was issue, my lord. NIT was issue, my lord. Now, in NIT, my lord, his technical bit was rejected, my lord. Now, subsequently, he submitted representation, my lord, and others rejected farm also submit representation, my lord. In term of that, my lord, we commissioner, my lord, power form a committee, my lord, to look into whole issue, my lord. Now, that report, my lord, has been finalized, my lord. Now, in term of that report, my lord, the competent authority, my lord, need to take a decision, my lord. Now, that I have placed before your lordship, my lord. So, this is, my lord, whether any grievance is, my lord, a rejection of his tender bid, my lord, taking a tender bid, my lord. He is against that he has filed this petition, my lord.
Respondent number 6 has been deleted.
that document was placed before this court.
The copy of the report is-
I am for 2, 3, 4, and 5, my lord. I have placed one record, my dated that is 22 March 2024, my lord. My lord say that, my lord.
What is that about?
That, my lord, we have formed a committee, my lord.
Hey, you are representing state.
My lord.
State was to take decision on the report.
No, yes,
Have you
my
taken
lord.
it?
No, my lord, not yet.
Not yet.
Not yet.
Praying for some more time.
My lord.
No problem, Mr. Listen from Land Council for the, you are for respondent.
Respondent, not respondent.
Okay. Praise for father, how much time?
4 weeks, my lord.
For the 4 weeks time.
Already on the last occasion.
Father, 2 weeks time, 2 weeks
4 week
time
time has been given.
to take decision on the report. As per the order dated 4/10/2024. Prayer allowed. Prayer not objected to by the Land Council for the respondent. You are Mr.
I'm El Sangam, lordship.
Let's see,
Lordship?
your good name,
El Sangam, lordship.
okay. Is it clear? Okay. Okay. So, this is prayed for common, this is matter.
May I
after 2
please
weeks.
pray for fixing a date, lordship? Because we are outstation council, so it is difficult
When,
for us.
when you want?
Can it be on
Okay, as
second
prayed for.
of December?
Is prayed for by the Land Council for the respondent. When do you want?
2nd of December.
Okay. 2/12. Okay.
Always much.
Lord, the last together, my lord.
Okay.
I pointed out the order. This is a challenge where a bail has been granted. That Milord will find the in order in page 15 of my bail application.
Supplementary hearing. The room is for respondent,
My lord, yes,
for the private respondent.
private respondent too, my lord.
Okay. Government is also there.
Milord, the issue involved
Hmm.
in this particular impugn order. Now, while passing this bail order, whether the parameters to be taken by the court by giving a reasoned order to grant bail was taken into consideration or not. That is the core issue in a crux of the matters of what this matter is concerned. Yes, of course, I agree with your lordship. My lord, on the last occasion pointed out that once a bail is granted, it's somebody's liberty, that liberty shall not be curtailed.
Okay.
I also agree to that extent. But now, how that has to be equated, how that has to be weighed, that what I'll tell your lordship. My lord, page 15 of the bail application, the impugn order, the entirely going through the entire order, my lord. My lord will not find even a reason how this bail was granted by the trial court. The only factor that was considered by the trial court, he is 70 years old.
Is
70 years old,
Hmm.
and he has been languishing behind about 1.5 years. There was only factor. Can that be a factor? Because the provisions under 437(1) is to be considered. It cannot be brushed aside while granting a bail. Because when a charge is in frame, there's a reasonably that prima facie that has come to a conclusion that he is the one, the respondent is the one who is an accused. Now, here in this matter, my lord, when I filed this application, three witnesses have given their deposition. Out of these three, two are his sister. The sister gave 164 statement before the magistrate, narrating the entire incident. And when they deposed before the court during the trial, they affirmed and they said that is their signature, and that is what they have stated before the magistrate. And that is also what they have stated before the IO. In that factual circumstances, my lord, how that, because when somebody has admittedly told to his sister that he is the one who has killed so-and-so, and by giving 164 statement under CRPC, and when they have affirmed it during the trial, the prima facie.
What is that affirmation?
But look, 164 statement is on oath, and they have given their deposition, and in their deposition they have stated that is what they have stated before the judicial magistrate.
They have indicated
They have. My lord, I respectfully take my lord to the deposition, and the record is also there, my lord.
record is there.
Record is there. Record was called for. My lord, deposition PW1, in the deposition portion,
PW1.
PW number 1.
It's at page.
My lord, I cannot say because the pages that is maintained by the
One
court.
64 witness. He is, one is 164 witness.
PW number 1, the deposition, not 164. But I'll come to 164 also.
No, he is a 164, 64 witness.
Yes, as well as deposition before the court
He is one.
legal trial.
1, 2 and 3.
My lord, the ones in 164 also you'll find in the record, but my lord, deposition of PW1, which was taken on, my lord, 4th day of September 2023. 4th September 2023. And 164 was given on 31st March 2023. PW number 1, my lord.
What is his name?
My lord, Takiyaku.
Okay, no, it's not there.
Takiyaku.
Just a minute. Huh? It's not properly paginated also in the position. So let's see. Yes.
Yes, my lord. I, Srimati Takiyaku, aged about 56 years, wife of so-and-so, 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 on court. I'm appealing on being summoned by this court. I know the person standing on the door. He is Nani Chatu. He is my elder brother. I don't know why my brother is standing on the door. Presently, after conclusion of so-and-so, some police officer, and on the river point of night, my younger sister, Tabarino, came back from Itanagar and halting the night at my residence at Duku village. While we were sleeping, she received a telephonic call from the accused and told me that he had a stomach ache and wanted to visit him. I and my sister went to the residence of accused at home village in the late night by her private car. We took him to GT Suite and Giro, and after order treatment from the doctor, we brought him back to his residence at home so-and-so. Thereafter, I and my sister came back to my residence the same night. Police are took me before magistrate, and I have given my statement before him. I do not put my term impression over the statement. This is what is said. Exhibit P1 is my statement before the magistrate. However, I deny Exhibit P1 as my RTIs. Address stays so-and-so. Now, on cross, in the night of 22/3/2023, my younger sister, Srimati Nami so-and-so, came to my residence from Itanagar. I have not disclosed to the police that in the night, Srinami told me and my younger sister that he had stayed so-and-so. It is a fact that in the night, so-and-so, after dropping the accused at his residence, I and my younger sister were going back to my residence. We noticed medicines and accused lying on the back seat of my sister's car. So we went back to his residence and delivered the medicine to him. I did not tell Nami Rakesh, Radesh, son of the accused, that his father had stepped so-and-so in the previous night and asked him to collect father's more. Put Iowa and the magistrate is I'm deposing today. This is what the elder sister said. Now, my lord, I respectfully take my lord to another sister. My lord.
This statement doesn't reveal anything.
No, the statement, what she says is, now the 164 statement was given. She agrees to that. She agrees to that. Now she says that she's an illiterate and she cannot, I'm not conversing with Hindi and Assamese language. She said even he is not conversing with this thing. Now, again, she says, I have given the same statement before the IO.
What she is stating now.
That has to be 164 statement that which is agreed. Exhibit P1 is my statement before the magistrate. She says exhibit P1 is my statement before the magistrate, then we have to look back to exhibit P1. What is exhibit P1? That may not find the 164 statement given by her.
Here probably she has retracted her earlier statement.
She
By this statement, by this deposition, saying that I do not understand any other language.
that was not.
And then what she is stating before
No,
this court.
Now, we are taking only one example of this one witness, my lord. Now, if we again go back to 164 statement, what she told before the magistrate?
That is what she is retracting, that she doesn't understand any other language. And she said,
No.
according to her,
No.
that what she is stating before this court. before
I
the court.
can understand, my lord. The relative will come and say that. She has not retracted. She said, this is my statement, but I have not put my signature. The only thing which she said is she doesn't even understand Hindi and Assamese.
Just see,
Now-
I have given, just see, I have given the same statement before the IO and the magistrate as I am deposing today.
Yes.
And what she has deposed today.
No. Now then, if we go back to 164 statement, where my lord will find the signature of the magistrate, and my lord will also find
It is,
that,
it
no,
is not a
that,
case.
no, that is why I'm coming. That's why I'm coming. There, while taking the statement, my lord, the magistrate has complied with all the formalities, even the videography was taken. And that was submitted to the IO with a 65-year certificate by the magistrate. That also my lord will find in the record of the case. Now, what she was saying, because it is not a case that videography was done. Everything was done by the magistrate. And if my lord finds in 31/3/2023 statement of this lady, it will be again crystal clear. Now she says, what I'm deposing today, that in that sense, my lord, in that sense, the magistrate is lying. If we go by that, because it was given on oath before the magistrate, which was recorded by the magistrate, in that sense, if she says that I have not given before the magistrate.
To that extent, probably, do we need to go? That will be appreciated by the trial court only.
My lord,
That whether that amounts to the acceptance or amount to the to acceptance or admission.
no, my lord, that
That
will
will be
come.
appreciated by the
Yes, my
trial court
lord,
only.
that will come at the time of the appreciation of evidence.
Yeah.
My lord, I agree with your lordship. Now, if we go by the another accused,
Witness.
another, I'm sorry, another witness. Now, PW number 3.
Yes.
My lord, I know the person standing on the door. He is Nami Chatung, his elder brother. On 3/4/2003, I have given my statement before so and so. Exhibit P3 is my statement, and Exhibit P3A, B, C are my signatures on it. It's another sister. Whatever I have stated in Exhibit 3 are true and similar to those stated before the magistrate investigating officer of the case. On 22/3/2000, I arrived in Giro to pick up my son from boarding school. At about 8 a.m. on the same day, my elder sister told me that our elder brother so-and-so was suffering so-and-so. I had brought my son from school to the residence of Sri so-and-so, so-and-so. At about 8 p.m., the accused called me over phone and said that he had stomachache and requested me to take him to the hospital. I and Srimati Takeyaku took the accused so-and-so. The MO and the attending nurse administered some oral treatment, and thereafter we drove him back to his residence. I have given statement to the Indian officer in the present case at Giro police station. I don't recollect the day and month, but it was in the year 2023. Now, at this stage, I don't know why she was declared hostile. She has been declared hostile. Now, at this stage, she has been declared hostile. Now, I own a personal car, Mahindra so-and-so. I'm reiterating that I came over to Giro on 2023 at about 8 a.m. from Nahalagan to pick my son. At the hospital, the accused received so-and-so from the attending nurse. On the night 2023, we are returning back to Smiti Takeyaku's residence. On the way, we found some oral medication so-and-so. It is not a fact that on the night of the accused had disclosed assaulting him in that night, which is personal night. It is also not a fact that Smiti Takeyaku. Now, I have not stated before the investigator said that the accused had confessed before me and so-and-so. In the morning of today, I left Giro so-and-so. It is not a fact that in the morning I came to know about the date of so-and-so. I never met and I don't know. No police official disclosed me that the accused was involved in the murder of the deceased. I did not tell anyone that through the news portal, I came to know that the accused had murdered the deceased. It is not a fact that I am deposing for statement to save the accused from being punished. Though, now by the defense, though I have admitted my depositional statement recorded under 164 in evidence. However, the prosecution side is not read over the entire documents of the documents. Now, again, what is this? CSS, no, my lord, assuming, like, just for the sake of assumption, is PW number 1 has said that she's illiterate, can't understand Hindi and Assamese. Let's assume for the timing this is right. Now, at least this lady understands, she understands the statement, she understands her signature, she has verified her signature, she has verified the statement. The only thing which she has said that this was not over to me on, this is what the plea that she has taken, even after going through the entire record. Now, if we go back to 164 statement, my lord, things are very clear. Things are such a crystal clear because normally statement under 164 on all this. But the lady who is literate has admitted that yes, this is a statement given by her, and that is her signature. And the son, in the latter stage, also admitted that that is a statement given by him, and that is his signature. So, out of these 3 witnesses, now, when things are so clear, when the bail was granted, my lord, it's admitted position that only 3 witnesses were examined, but 1 witness is this. So now it is a 302A, the heinous crime. These parameters were not taken while considering the bail. The only thing is that she has spent about 1.5 years behind the bar. That was the only criteria. That was the only reasoning that I should say. Because at the stage of bail, she has also, Lordship has found out on the last occasion that the knife didn't have the blood of the human group. That cannot be true. So this is prima facie. This statement is a prima facie that he has, at least at this stage, he has committed a crime. Prima facie. What is 437, my lord? I don't need to tell your lordship to 437 because my learned friends of defense, everybody will know 437. It cannot be brushed aside. My lord, let me go to 437, my lord. What 437 says. And Supreme Court has come down heavily that this 437(1)(1) cannot be brushed aside, even by the High Court, even by the Supreme Court. Why? Taking a case of a bail of heinous crime. The ground of bail has been changed. Justice Hima Kohli recently in 2024 has passed discussing all this, how this bail has evolved and why this cancellation is required. If it is perverse, illegal, and not judicious. Because if the discretionary power is exercised, especially by the lower court, in a very arbitrary manner, then bail needs to be cancelled. My lord, when bail may be taken in case of non-bail, my lord, I'm just again revisiting, my lord, as your lordship is well aware, everybody is well aware of this. When any person accused or suspected of commission of any is arrested or detained without warrant, such persons shall not be released if there appear reasonable grounds for believing that he has been guilty of an offense punishable or imprisonment of life. The reasonable ground, it's not a finding that he has killed or he has not killed. It's just a reasonable ground that he has been guilty of an offense with that. 302. So the reasonable ground is this is reasonable ground. My lord, I respectfully submit this decision. My lord, this is one of the recent judgment passed by the Honorable Supreme Court. When this was considered, when a bail has to be cancelled. My lord, respectfully, I take my lord to page number 9 of the decision. My lord, it just analyzes the principle governing grant of bail. Section 439 of the CRPC is a guiding principle for adjudicating a regular bail application, wherein court takes into consideration several aspects. The jurisdiction to grant bail has to be exercised cautiously on the basis of well-settled principles having regard to the facts and the circumstances of each case, my lord. So before I take my lord to this paragraph 20, my lord, just want to assist your lordship and would like to submit that here CCTV footage are there, everything is there, my lord. Now, in Prahlad Singh case, a two-judge bench of this court started the principle which are to be considered while granted. The jurisdiction to grant bail has to be exercised on the basis of well-settled principles having regard to the circumstances of this case and not in an arbitrary manner. While granting the bail, the court has to keep in mind the nature of accusation, the nature of evidence in support thereof, the severity of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witness being tampered with the larger interest of the public or state, and similar other consideration. It has also been kept in mind that the purpose of granting the bail, the legislature has used the word reasonable grounds for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy it as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. It is not accepted at this stage to have the evidence establishing the guilt of the accused beyond reasonable doubts. It has been distinguished, my lord. The reasonable grounds for believing or establishing the guilt of the accused beyond reasonable doubt. Now, my lord, coming to para 21, as reiterated by the two just bands of this court in Prasanna Kumar Sarkar, PK Sarkar is very common, my lord. It's well settled that the factors to be borne in mind while transferring an application for bail are whether there is a prima facie or reasonable grounds to believe that the accused had committed offense. Whether there is a prima facie or reasonable grounds to believe that the accused had committed an offense. Nature and gravity of the accusation, severity of the punishment in the event of conviction, danger of the accused absconding or fleeing so-and-so, character so-and-so. Now, here in this particular case, my lord, even when he was produced before the court, my lord, even the record will reveal that the accused wanted to confess that, yes, I'm the one who has done. That is also in the record of the case, my lord. However, the magistrate, in a very judicious manner, warned the accused not to do such thing. And that was the duty of the magistrate, my lord, to apprise him about the law, my lord. Now, but the decision in Prasanna has been consistently followed by this court in many of the cases, my lord. Now, in a recent pronouncement, paragraph number 3, Honorable so-and-so, the impugn order passed by the High Court, if the impugn order passed by the High Court is cryptic and does not suggest any application of mine. Now, my lord, going back to the order passed by the trial judge, my lord, the order simply says, my lord, the order simply says the evidence collected by the investigator and the ocular evidence as well as the documentary evidence show that the victim died as a homicidal death. One part. I have also given due consideration to the grounds pleaded by the accused as well as his age. He is stated to be 72 years of age, having permanent residence of home village at Kim so and so. This is one. Now, another factor submitted by the defense is that he has spent 1 year and 2 months in judicial lockup since his arrest. 1 year and 2 months. So these are the two factors. No doubt, the court went to in one part, the court said that the knife doesn't contain a human blood proof, even though that's a human blood. But again, at the time of framing of charge, the accused has admitted that he has burned all the clothes that he wore on that day. Therefore, he was also charged under 201 for destroying evidence. And he has admitted that. Not only under 302, it's under 201 also. The factor was only that, so having regards to the entirety of the evidence and place on record, this court is of considered view that the accused can be admitted on bail. So the Supreme Court says that there has to be a reason for granting the bail. Simply on perusal of this so and so, it cannot be. That I'll come to that also. Now, the impugn order passed by the High Court is cryptic, para 23, and does not suggest any application of mine. Going back to Deepak Yadav, my lord. Going back to Deepak Yadav. The impugn order passed by the High Court is cryptic and does not suggest any application of mine. There is a recent trend of passing such orders, granting or refusing to grant bail where the court makes a general observation, the facts and the circumstances have been considered. No specific reasons are indicated which precipitated the passing of the order by the court. Now, Supreme Court has come down so heavily that this has become a very general trend. Such a situation continues despite various judgments of this court, wherein this court has disapproved such practice. Now, in case of Mahipal, my lord, I'm coming to that. Merely recording having perused the record, my lord, merely recording having perused the record and on the facts and circumstances of the case does not serve the purpose of a recent judicial order. It is a fundamental premise of open justice to which our judicial system is committed, that factors which have weighed in the mind of the judge in the rejection or the grant of bail are recorded in the order passed. Open justice is premised on the notion that justice should not only be done, but should manifestly and undoubtedly be seen to be done. The duty of the judge to give reasoned decisions lies at the heart of this commitment. Questions of the grant of bail concern both liberty of individuals undergoing criminal prosecution as well as the interest of the criminal justice system in ensuring that those who are commit crimes are not afforded the opportunity to obstruct justice. Judges are duty bound to explain on the basis which they have arrived at a conclusion. Now, what is the basis in this particular impugn order, my lord? For grant or denial, but the nature of crime has a huge relevancy. The key considerations which govern the grant of bail were elucidated in the judgment of this court in Ram Gopi Upadhyay and so and so. Now, it was observed by this court, that Supreme Court, apart from the above, certain other which may be attributed to a relevant consideration may also be noticed. Though, however, the same are only illustrative and not exhaustive, neither there can be any. The condition being, while granting bail, the court has to keep in mind not only the nature of, but the severity of the punishment if the accusation entails a conviction and the nature of evidence in support of the accusation. Reasonable apprehension of the witness being tempered or the apprehension of there being one of the factor, but it is not expected to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought always to be a prima facie satisfaction of court in support of the charge. Now, at the time of the considering a bail application, it is not expected to have the entire evidence establishing the guilt of the accused beyond this, but there ought always to be a prima facie satisfaction of the court in support of the charge. Now, what is the charge? Now, what is the prima facie thing? The prima facie satisfaction. The request is mandating CCTV footage is there. He has destroyed the cloud, he is admitted. He wanted to confess before the magistrate. Two sisters and one son has given one sister statement implicating the father. Now, frivolity in prosecution should always be considered, and it's only the element of genuineness that shall have to be considered in the manner of bail in the event of there being some doubt as to the genuineness of the prosecution. In the normal course of events, the accused is entitled to an order of bail. That is in the frivolous case. So, the care has been taken for the accused also, and the interest of the society also, in the light of 437(1)(1), my lord, that this particular 437(1)(1), my lord, I have given the judgment also earlier. Narendra K 2008-13 SCC 584, my lord, I have already placed. We have submitted all the decision. My lord, huh? My lord, I have got one extra. Many judgments you have. My lord, Narendra K, admin doctor, State of Gujarat under 2008-13, my lord. I've got one extra also, my lord. My copy, if I have marked somewhere, it might be excused, my lord. But this is the best copy I'm having, my lord.
Yeah.
My lord, I respectfully tell my lord to para. I'll start from 19, my lord. That my lord of para 19. The High Court also erroneously held that there was a ban in granting bail in heinous crime. Because I have chosen this 19 because it cannot be done. There cannot be total ban. It has been fairly accepted by learned counsel for the parties that in some judgment and expression, appeal in respect of an order of grant or bail has been used in the same sense that state can move the higher court. Though the High Court appears to have used the expression ban on the grant of bail in serious affair, actually it is preferable to the decision of Kalyan Chandra Sarkar as it was noted so and so. The law in regard to or refusal of bail is very well settled. The court granting bail should exercise its discretion in a judicious manner.
Now you are reading,
My lord,
now you are reading which para?
my lord, I am reading para 21.
Okay.
That is the excerpts of the Kalyan Chandra in this particular judgment.
Yeah.
The law in regard to the grant of bail is very well settled. The court granting bail should exercise its discretion in a judicious manner and not as a matter of course. Though at the stage of granting bail, a detailed examination of evidence and elaborate documentation of the merit of the case need not be undertaken, there is a need to indicate in such orders reasons of prima facie concluding why bail was being granted, particularly where the accused is charged of having committed serious offense. This is what has to be reflected in the bail law. Any order devoid of such reasons would suffer from non-application of mine. It is also necessary for the court granting bail to consider, among other circumstances, the following factors also before granting bail. They are the nature of accusation and the severity of the punishment in case of conviction and nature of supporting evidence. Now, reasonable apprehension of tampering with the witness or apprehension, this was another factor. Prima facie satisfaction of the court in support of the charge, which I have just read, my lord. It was also noted in the said case, my lord, that the condition laid down under section 437(1)(1) are sine qua non for granting bail, even the section 439 under 439. 439 says the power of the High Court and Session Court to grant bail, even though we feel that for trustees when is restricted to magistrate, but it's not. Even this has to be taken. Even a distance of 439. In paragraph 14, it was noted in Rajesh Rajan case. Now, my lord, we have already noticed from the arguments of learned counsel for the appellant that the present accused had earlier made 7 applications showing granting. Now, why I'll just come down a little that my lord will find a mark E in the right side. While cancelling the said bail, this court especially held, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 line, my lord. That my lord will find in between G and E, my lord. While cancelling the said bail, this court especially held that the fact that the present accused was in custody for more than 1 year at the time, and further fact that while rejecting an earlier application, the High Court had given liberty to renew the bail application in future, were not grounds in vices under 437(1) of the court. Now, that particular ground was taken that 1.5 years he spent behind a bar. Now, here in our case, it is grounded 1 year and 2 months. But my lord will be surprised even to come that in this paragraph, my lord, I'll just come down. Now, liberty, this court also in specific terms held that the condition laid down under 431 is sine qua non for granting bail, even under section 439 of the court. In this impugn order, it is noticed that the High Court has given the period of incarceration already undergone by the accused and unlikelihood of trial conducting in the near future as grounds sufficient to enlarge the accused on bail. In spite of the fact that the accused stands charged of offense punishable with a life imprisonment or even death penalty. Here, same case 302. Now, even the High Court has given a reasoning that this is not going to be over in a very near future, and he has spent about 1 year and 6 months. Now, in spite of the fact that the accused stands charged of offenses punishable with a life or even a death penalty, in such cases, in our opinion, my lord, in such cases, in our opinion, the mere fact that the accused has undergone certain period of incarceration, 3 years in this case, by itself would not entitle the accused of being enlarged on bail. In such cases of heinous crime, even though he has spent about 3 years, it doesn't entitle him to grant bail. Now, our case is only 1 year and 2 months. Of course, said that 72 is. Now, by so entitled accused to being enlarged on bail, note the fact that the trial is not likely to be concluded in the near future, either by itself or coupled with a period of incarceration, would be sufficient for enlarging appellant on bail when the gravity of the offense alleged is severe and there are allegations of tampering with the witness by the accused during the period so and so. Now here, in our case, my lord, 1 year and 2 months, and already 3 depositions were met. Out of the 27 witnesses, 3 have been met on the day when bail was granted. And now the court also has given an opinion, just because this 1 year and 2 months was taken just because the presiding officer was on leave for 6 months. Now, coming back to Deepak Yadav case, my lord, para 25 of Deepak Yadav. Deepak Yadav case. Similarly, the parameters to be taken, Deepak Yadav para 25. Similarly, the parameters to be taken into consideration for grant of bail by the courts has been described so and so. The law in regard to grant of refusal bail is very well settled. The court granting bail should exercise its discretion in a judicious manner and not as a matter of course. Though at the stage of granting bail, a detailed so and so is not required. It has flows down in the same manner, my lord. Now, it also says about the prima facie satisfaction charge in support of the case. Now, recording of reasons for grant of bail by the High Court of the Session Court, it should be. That next page 14. The importance of assigning reasoning for grant of bail, that my lord, para 26, can never be undermined. There is prima facie need to indicate reasons, particularly in case of grant or denial of bail where the accused is charged with a serious offense. The sound reasoning in a particular case is a assurance that discretion has been exercised by the decision maker after considering all the relevant grounds and by disregarding extraneous consideration. This is very important. How a reasoning order can be read. A 2-judge bench of this court in Ramesh Bhavan so and so held that the duty to record reasons is a significant safeguard which ensures that the discretion which is entrusted to the court is exercised in a judicious manner. The operative portion of the judgment read as under, we disapprove the observation of High Court in a succession of orders in the present case recording that the counsel of the party do not press for further region order. The grant of bail is a matter which implicates the liberty of the accused, the interest of the state and the victims of crime in a proper administration of criminal justice. My lord, the grant of bail is a matter which implicates the liberty of the accused, one part, the interest of the states, another part, and the interest of the victims of the crime, in which, like in the proper administration of the criminal justice. Now, it is a well-settled principle that in determining so as to whether a bail should be granted, the High Court or that matter, the Session Court, deciding an application under 439 would not launch upon a detailed evaluation of facts on merit since a criminal trial is still to take place. This observation, while adjudicating open bail, would also not be binding on the outcome of the trial. But the court granting bail cannot obviate its duty to apply a judicial mind and to record reasons, brief as they may be, for the purpose of deciding whether or not to grant bail. The consent of the parties cannot obviate the duty of the High Court to indicate its reasons why it has either granted or refused bail. This is for the reasons that the outcome of the application has significant bearing on the liberty of the accused on one hand, that what your lordship has said on the last occasion, but as well as the public interest in due enforcement of criminal justice on the other. The rights of the victims and their families are at stake as well. Now, if we only go by the liberty that has to be given to the accused in this administration of criminal justice system, what about the right that the victims and their families? The victims and their families are also at stake because they have lost some available one from the family because of a certain act committed by the accused. These are not matters involving the private rights of two individual parties. As in a civil proceeding, the proper enforcement of criminal law is a matter of public interest, my lord. The proper enforcement of criminal law is a matter of public interest. We must therefore disapprove the manner in which a succession of orders in the present batch of cases has recorded that counsel for the despot do not so and so. If this is a euphemism for not recording adequate reasons, this kind of formula cannot seal the order from judicial scrutiny. Therefore, now the order, the impugn order before your lordship, will it be subjected to judicial review, as it has not given any reasoning? Now, grano bail, my lord, under section 4 CRPC is a matter involving the exercise of judicial discretion. Judicial discretion is granting or refusing, as in the case of any other discretion which is vested in a court as a judicial institution. It's not unstructured. The duty of the court is a significant safeguard which ensures that the discretion which is entrusted to the court is exercised in a judicious manner. The recording of reasons is a judicial order. Ensures that thought process underlying the order is subject to scrutiny and that it meets objective standards of reason and justice. Why it is for judicial scrutiny? That it meets the objective standards of reason and justice, my lord. And similarly, my lord, this is the Ketina of judgment, my lord, where the Supreme Court recently has come down very heavily in 2002, my lord. It was authored by Justice Sima Kohli, my lord.
2000?
It is 2022, in 2022, and I have got another also in 2024, which this has been reflected. So, my lord, the equation has been changed now because of unreasoned order passed by the trial courts. Now, in Mahipal's case, my lord, in Mahipal's case, the wording has become so specifically that it has come, my lord. My lord, I just read on para 28. What it has says again and again in Ram Govind, grano bail though being discretionary order, but however calls for exercises in a judicious manner and not as a matter of course. Order for bail bereaved of any cause and reasons cannot be sustained. Now, needless to record, however, that the grano bail is dependent upon the contextual facts of the matter being dealt with by the court, and facts, however, do always vary from case to case. Definitely, my lord. While placement of the accused in the society, though may be considered, but that by itself cannot be a guiding factor in the matter of grano bail, and the same should and or always be coupled with other certain warranting the grano bail. The nature of offense is one of the basic considerations for the grano bail. Bail more heinous is a crime, the greater is the chance of rejection of the bail. But it's 302. In IPC, my lord, 302 is the extreme offense that a person can commit is murdering another person. An extreme offense with certain condemnation that can be committed by any person is rape, my lord. The nature of the offense is one of the basic considerations for grant of bail. More heinous a crime, the greater is a chance of rejection of bail, though however dependent on the factual matter. A two judge bench of Mahipal, my lord. In Mahipal, wording is very clear, very categorical. It says the provision for an accused to be released on bail touches upon the liberty of an individual, right? It is for this reason that this court does not ordinarily interfere with an order of the High Court granting bail. However, where the discretion of the High Court to grant bail has been exercised without due application of mind or in contravention of the direction of this honorable court, such an order of grant bail is liable to be set aside. The very wording that they have used is liable to be set aside in Mahipal case. The court is required to factor, amongst other things, prima facie view that the accused had committed offense. This is a factor, my lord. That the accused has committed the offense. In PW number 1, even says, even your lordship says she has retracted that the statement is right, but I have not put my thumb signature. But what about PW 3? She has affirmed everything. This is my statement, this is my signature, this is what I have stated. Except the fact that the 164 statement was not read out, but she admitted this is a statement. She is a literate lady. Unlike PW1, for the timing, she says she doesn't even understand Hindi. And in Arunachal, if somebody says that they don't understand, my lord, at least living in that town area, my lord, I cannot say about the interior part, but at least in Naharlagan, Jiro, Bandardawa, Itanagar, at least, my lord, at least they will have a minimum knowledge of Hindi. Now, these are, all this has come down about the reason order, my lord. Now, I take, my lord, to the impugn order. I have already taken. So, what is the reason of the impugn order? And if this is the factor and prima facie, there's no reason in that granting of bail, and if my learned friend says that I need to take to the records of the case, especially the framing of charge. And if my learned friend says that this is a reason order, that's a different thing. Especially even at the time of framing of charge, he has admitted, my lord will find, in fact, as it is not being paginated with the court documents and our document, my lord. So, troubling our lordship also. my lord, the charge was framed on 22/8/2023.
Yes, he pleaded not guilty and claimed to be tried.
Madam?
He pleaded not guilty and claimed to be tried.
Yes, that is true. It's under also 201. Now, it was explained. Then he said that he wants that the trial. Now, here, how it has been established by the prosecution, the charge sheet will reveal that. The narration of the charge. My lord, cutting is short, my lord. Now, there was also occasion that I will not say because Lordship will not appreciate that. On 17/4/2023, my lord, just for the sake of it. Even your Lordship will not agree with my submission, but even then, I would like to draw the indulgence of your Lordship. Because on 17/4/2023, when he was produced before the Chief Judicial Magistrate, the accused Nani, I'll just read out, my lord. It was on 17/4, then being part of the record. Accused Nani Chatung is present on being present from Johnson. The accused is willing to confess his guilt. My lord.
He was under judicial custody. As well.
My lord, that is what I say.
Yes.
My lord will not appreciate that.
Yes.
The accused is willing to confess his guilt. I have explained to the accused regarding legal provisions, and the magistrate has done his duty. And thereafter granted one time for reflection of mind. Hence, the accused is remanded back. Now, thereafter, the accused wanted to confess in the first instance, my lord. Now,
the magistrate is not saying that accused wanted to give a confessional statement. Says that
the order,
one
it goes in
confess
this
guilt.
manner. That's what. It ought not to have even reflected in the order, my lord. That lordship is right. It ought not to have been reflected. The magistrate just gave it just like that. Accused Nanija is present on being produced from so for recording his statement under 164 in the stand case. He was produced. He came. He wanted to give. The accused is willing to confess his guilt. It should not have been reflected. I have explained today. It ought to have been some just explanation in the chamber that you are supposed to do this explanation, but it has been reflected in the order that the accused is willing to confess, and I have explained. Yes, lordship is right. Therefore, I say before, your lordship would not appreciate this. But why I'm inviting your lordship in this particular that there's a judicial cognizance has been taken by the magistrate, the accused is willing to confess. I'm just summing up the things, my lord.
And he has given the 164 statement also.
He has not given. Thereafter he rejected. After that, he was given a time, but that ought to have been done as a procedure, but ought not to have been reflected in an order, say, his willingness to confess. Yes, it has been reflected, the willingness to confess in the order, say. Somehow, it seems like the accused wanted to explain, and the magistrate was stopping from explaining. But I would rather submit that the magistrate was doing his duty, but that ought to have been done inside the chamber. But it was reflected. So it was a tussle between the accused and the magistrate. The accused wanted to confess, the magistrate, no, you don't confess, this is a legal provision. When he was volunteered to confess, again, that particular legal provision was taught. I'm just drawing this attention, your lords. I say nothing much on the legally that it may not have a legal stand, but the particular thing that who has committed a crime on the series of the matter. And there's a CCTV footage. Only one thing that, even though I submit that the Honorable trial court has only given one option, only one thing, that he has given an adverse remark in the entire record. He has not given any remark on the 164. He has not given any remark on the CCTV. He has not given any remark on the destroying of the evidence by the accused. The only remark that he has given, that the knife is, the blood group cannot be ascertained for the knife. By that remark, coupled with 70 years and having spent more than 1 year and 2 months, he was granted bail without any reason. Whereas Supreme Court has said with a reasoning, even somebody has stayed for 3 years, doesn't entitle him to release on bail or in the heinous nature of the crime. Now, what is the reason in this particular case? Without any reason, he has been released on bail. Well, my learned friend will submit. Thereafter, if needed, I'll reply.
Malad, it's too much time has taken, Malad. I was taking troubles. Malad, anyway, Malad, I'll not take much time. In a shortcut, I'll submit, Malad. But the first thing, Malad, the petition is coming up for cancellation of the bail granted by the trial court. Now, in this, when the bail granted by the trial court is challenged, there's a parameter and there's exceptional ground. There must be overwhelming and supervening event warranting for cancellation, Malad. That is another thing, Malad. I'll refer all those, the facts and also. Okay. Now, even if we go by the entire records, Malad, there are not a single, not to talk of any doubt, even there's no any eyewitness, there's no any material eyewitness, there's no question of any prima facie case at all. And whatever decision my learned friend has referred to, madam, this is all about the bail which has been rejected by the trial court after considering the material. But despite of rejected by the trial court, the High Court has granted bail without assigning proper reason, without explaining as to on what ground, how that, without explaining even why overruling that the judgment and over intervening the decision of the trial court, man, rejecting bail. That is why the most of the case referred by him is with regard to that. Trial court rejected bail, High Court exercising 439 granted bail without having reference to the rejection order made by the trial court. That is what the even Prasanto Kumar Malod has referred. But this all about only a single 2 sentence, Malod, 2-3 sentence, the bail has been granted. On that aspect, Malod, when the trial court has rejected a bail, while granting higher court, High Court 439, they ought to have referred at least the rejection order and why the rejecting without quashing the rejection order, why the trial or why the bail has been granted despite of rejection. That the region that has not been most of the case, that is the case which is been referred. Therefore, it is distinguishable and it's not applicable to the present case, Malud. It's my humble, respectful submission. Malud, straight away, Malud, as I've said, Malud, this is for cancellation, bail granted by the learned trial court. Malud, yes, Malud knows that exceptional, overwhelming, supervening event must be there. Malud, straight away, I'll come to my affidavit, Malud. Affidavit filed by respondent number 2, Malud. Yes, Malud. The impugn order annexed by my learned friend in the criminal petition, Malud, it's not legible in my service copy, Malud. That's why, Malud, I've annexed affidavit opposition number filed by respondent number 2. Malud, why I'm referring this, Malud?
Yes, sir.
My lord, why I'm referring this, my lord, I'll come to this, my lord, whether trial court taking into consideration old age of the accused can be a ground for granting bail. Mal, this whole aspect, mal, I'll deal with after perusing this, the impugn order, mal. Impugn order, start from page 26 of my affidavit of apportionment. I'll just, although it has been read, but for my perspective point of view, I'll just again read it, my lord. Not all, but on the relevant paragraph, my lord. This is paragraph 2 from bottom, my lord. Paragraph 2 from bottom, my lord. Not Mr. So-and-so, and T.T. So-and-so, counsel for a complainant strongly oppose granting to the accused, citing the accused being retired police officer has shown his influence in past. As such, there is chance of being threatening the witness who are yet to be examined. And next, my lord, next paragraph down below again. Learned P.P. So-and-so submit that one eyewitness of the offense is yet to be examined, and he being known naturally, the accused may intimidate and coerce him, and so as to depose or give evidence favorable upon next matter upon hearing the counsel on a fact and a law. I have thoroughly perused the records. My lord will mark. I have thoroughly perused the record. It is relevant in the later course of my lord. I have thoroughly perused the records till so and so that 14/6/2024, prosecution has examined 3 witnesses. 2 witnesses are stated to be family relatives of the accused. I have also seen so-and-so, madam. The CFSL report, which indicates that blood stain found in the weapon of the offense was of human being, blood group of any person not disclosed in the report. Next paragraph, madam, again. Investigating officer has listed 27 prosecution witnesses, only 3 have been examined so far. Presiding officer was so-and-so. My lord, 3 witnesses, so far, as of now, my lord, 6 witnesses have been examined, including what they've said, the eyewitness, my lord. There's no material eyewitness, my lord. Now coming to the next page, 28, my lord. Just relevant page, paragraph I'm highlighting, my lord. Now the reason, my lord, reason for granting at page 28, my lord. Page 28, the evidence, my lord, second paragraph, page 28. The evidence collected by the investigator and ocular evidence as well as documentary evidence show that the victim died as homicidal death. I have also given due consideration, my lord. I have also given due consideration the ground pleaded by the accused as well as his age. He is stated to be 72 years of age, having permanent resident of so-and-so. On these, this is the reason, my lord. The learned trial court has examined, has thoroughly perused the available records, and thereafter, my lord, and this age factor, old age factor, was also taken into account, consideration, my lord. Now, on this, when having considered this aspect, on a merit, accused was enlarged on bail. Now, straight away, my lord, under these facts, my lord, the age factor and all, my lord, I'll come to that point, my lord, especially for cancellation of the bail granted by the trial court, my lord. There has been cutting out the decision, my lord. Well, this is to be excised only in exceptional circumstances, my lord. The first, my lord, Dolatram case, my lord. This is about Dory that the gravity, my punishment is life imprisonment, my lord. Dolatram, my lord, para 4 and 5. Para 4, my lord. Rejection of bail in a non-bailable case at any initial stage and the cancellation of bail so granted have to be considered and dealt with the different basis. Very cogent and overwhelming circumstances are necessary for an order directing cancellation of the bail. already granted. Generally speaking, the ground for cancellation of bail, broadly illustrative and not exhaustive, are interference or attempt to interference with the due course of the administration of justice, or evasion or attempt to evade the due course of justice, or abuse of the concession granted to the accused in any manner. The satisfaction of the court on the basis of material placed on the records of possibility of accused absconding is yet another reason justifying the cancellation of bail. However, bail once granted not to be cancelled in a mechanical manner without considering whether any supervening circumstances have rendered it no longer conducive to fair trial, to allow the accused to retain his freedom by enjoying the concession of the bail during the trial. These principles, it appears, were lost sight by the High Court when it decided to cancel the bail already granted. The High Court, it appears to us, overlooked the distinction of the factor relevant for rejecting bail in non-bailable case in the first instance and cancellation of bail already granted. Para 5 months. We are therefore satisfied the cancellation of anticipatory bail granted to the appellant for the reason given by the High Court was not justified. Nothing has brought to our notice either from any interference, any may possible to draw that the appellant have in any manner whatsoever abused the concession of the bail during the intervening period. My lord. This one as the dollar dram case. Now coming to the next, my lord. It is 2020, my lord. My lord, this is relating to 302, my lord. Makela Dramrajan. This relates to 302, my lord. Para 8, my lord. Para 8. In Raghuveer Singh versus State of Bihar, this court held that bail can be cancelled where accused misuses his liberty by indulging in similar criminal activity. 2. Interfere with due course of investigation. 3. Attempts to tamper with the evidence or witness, threaten witness, or indulge in similar activity which would hamper a smooth investigation. 5. There is likelihood of his fleeing to another country. 6. Attempt to make himself scarce by going underground or becoming unavailable to the investigating agency. 7. Attempt to place himself beyond the reach of the security. The above ground are illustrative and not exhaustive. It must be remembered that the rejection of bail is stand on one footing, but the cancellation of bail is harsh order because it interferes with the liberty of the individual, and hence it must not be lightly resorted to. Para 10. Having perused the law laid down by this court on the scope of power to exercise in the matter of cancellation of bail, it is necessary to examine whether the order passed by Session Court granting bail is perverse and suffered from infirmity which has resulted in the miscarriage of the justice. No doubt, Madam, this is important. Madam, this is directly related to the impugned order reflected as it is, Madam. No doubt, the Session Court did not discuss the material on record in detail, but there is an indication from the order by which bail was granted that entire material was perused before grant of bail. It is not a case of either the complainant or respondent or state that irrelevant consideration or that it is not a case that the entire complainant or so the irrelevant consideration have been taken into account by the Session Court while granting bail to the appellant. The order of Session Court by which the bail was granted to the appellant cannot be termed as perverse, as the Session Court was conscious of the fact that investigation was completed and there's no likelihood of appellant tampering with the evidence. Now, same as the 11, the petition for cancellation of bail is both on the ground of illegality of the order passed by the Session Court and the conduct of the appellant subsequent to their release after bail was granted. The complaint filed by the so-and-so, my lord, so-and-so, is placed on record by respondent number 2. It is stated in the complaint that the appellant were roaming freely in the blaze and threatening witness. We have perused the complaint and found that allegation made therein are vague, and there's no mention about which accused out of 15 indulged in act holding out threat to the witness or made attempt to tamper with the evidence. After considering the submission made on behalf of the parties and examining the material on record, we are of the opinion that the High Court was not right in cancelling the bail of the appellant. The order passed by Session Court granting cannot be termed as a published matter. This is exactly what the learned trial court has examined after having perused all the material, my lord. Yes, granted by applying judicious mind, lord. This is, my lord, what it has been in the present, in Makela Drum Raz case, it has been stated, emphasized. Now, my lord, next is, my lord, 3-bench judgment, my lord. It's a 3-bench judgment, and the offense relate to 376, my lord. Here, my lord, what could be ground, my lord? Detailed ground has been enumerated by the larger bench of the Honorable Supreme Court, my lord. My lord, here the fact is, my lord, this is altogether fact, my lord. Para 24, my lord. Here in this case, my lord, the bail was granted before CC, my lord. CC was framed, my lord. P versus State of Madhya Pradesh, my lord. In that case, my lord, even after releasing, my lord, that was on the factual aspect is different, my lord. Now the coming to the law point, my lord, relevant for the purpose, my lord. Para 24, my lord. Para 24. As can be discerned from the above decision, for cancelling bail once granted, the court must consider whether any supervening circumstances have arisen or the conduct of the accused post grant of the bail demonstrate that it is no longer conducive to the fair trial to permit him to retain in his freedom by enjoying the concession of the bail during trial. To put it differently, in ordinary circumstances, this court would be loath to interfere with an order passed by the court below granting bail, but if such an order is found to be illegal or perverse or premised on the material that is irrelevant, then such an order is susceptible to the scrutiny and interference by the appellate court. Para 25. Some of the circumstances where a bail granted to the accused under section 439 CRPC can be cancelled are enumerated herein below. Number 1, if he misuses his liberty by indulging in similar and other similar activity, if he interferes with the course of investigation, if he attempt to tamper with the evidence, if he attempt to influence or threaten the witness, if he evade or attempt to evade the court proceeding, if he indulge in activity which would hamper the smooth investigation, if he is likely to flee from the country, if he attempt to make himself scarce by going underground, so and so, if he attempts place himself beyond the reach of his security, this is the parameter on the ground which the bail granted by the trial court can be cancelled by the High Court. Now, next is herein the age factor, old age factor can be a valid ground for consideration of trial court or not, my lord. Para, just I'll see para 16, my lord, is I highlighted. Here, my lord, the accused was 55 years Para 16, my lord. Further, the fact that appellant is a lady in 55 years of age cannot be ignored, particularly when examining a question of grant of regular bail, my lord. In our case, 72 years old man. He's 55 months. In this case, 55 months. This is the valid ground for consideration for a granting of bail, my lord. Now, on this aspect, my lord, this age factor cannot be ignored, my lord, for granting regular bail. Now, basing on this principle, para 19, 20, my lord. It remains trite that normally very cogent and overwhelming circumstances or ground are required to cancel the bail already granted. Ordinary, unless a strong case based on supervening event is made out, an order granting bail is not to be lightly interfered with under section 439(2) of CRPC. It had not been the case of the prosecution that the appellant had misused the liberty or had comported himself in any manner in violation of a condition imposed on her. We are impelled to observe that the power of cancellation of bail should be exercised with extreme care and circumspection, and such cancellation cannot be ordered merely for any perceived indiscipline on part of the accused before granting bail. In other words, power of the cancellation of bail cannot be approached as if the disciplinary proceeding against the accused. And in fact, in a case where a bail has already been granted, the upsetting under section 439(2) of CRPC is emphasized only in such cases where the liberty of the accused is going to counteract this requirement of the proper trial of the criminal case. In the matter of the present nature, in our view, over-expansion of the issue was not required only for one reason, that a particular factor was not stated by the trial court in its order granting bail. Now here the 55 age, that was a valid ground. Because this is a valid ground for consideration of the bail. Now accordingly, in the our case, the age 55 and 75 was taken into consideration. Now, this is all about under what circumstances only the cancellation, power of cancellation can be exercised, This is elaborately discussed, Now, even coming to the bail, it is subtle principle, To that extent also, there's no illegality on part of the trial court by granting the bail, Just regarding, the granting of notes, the granting the accused, unless and until accused is found proven guilty beyond reasonable doubt, but it's to be the fundamental principle of innocence has to be accepted, This, the para 21, Yes. Para 21, I'll just I highlighted it. In a bail application, generally, it has been laid down from the earliest time that object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that the accused will stand in his trial when called upon. The court or more verbal respect to the principle that the punishment began after conviction and that every man is deemed to be innocent until duly tried and duly found guilty. Para 22, From earliest time, it was appreciated that detention in custody pending completion of trial should be cause of great hardship. From time to time, necessary demands that some unconvicted persons should be held in the custody pending trial, secure their attendance at a trial. But in such cases, necessity is the operative test. In this country, it would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any manner upon which he has not been convicted or that in any circumstance he should be deprived of his liberty upon only of the belief that he will tamper with the witnesses if left at liberty, save in the most extraordinary circumstances. 23, my lord. Apart from the question of preventing being object of the refusal of the bail, one must not lose sight of the fact that imprisonment before conviction has a substantial punitive content, and it should be improper for any court to refuse bail as a mark of disapproval of a former conduct, whether the accused has been convicted or not, or to refuse bail to an unconvicted person for the purpose of giving him test of punished imprisonment a lesson. Para 27, man. This court, time and again, has stated that bail is a rule and committal to jail is an exception. It has also observed that refusal of bail is a restriction on the personal liberty of the individual granted under Article 21 of the Constitution, man. Now, the same principle, my lord, there are 5, my lord. Referring the Gurbakh Singh, the 5 Constitution bench, my lord. There are 5. The historical background of the provision of bail has been elaborately and lucidly explained in the recent decision delivered in Nikesh Chand Tarachand Saab. So going back to the day of Magna Carta, in that decision, reference was made to the Gurbakh Singh Siva, in which it is observed that it was held way back in Nagendra Nath Chakravarti in relation. So the bail is not to be withheld as a punishment. Reference was also made to so-and-so, wherein it is observed that the grant of bail is a rule and refusal is exception. The provision of bail is therefore all age, and a liberal interpretation to the provision of bail is almost century old, going back to the colonial days. Now, in the recent judgment, my lord, this September, my lord, the Honorable Supreme Court in the Kejriwal, my lord, had also highlighted a basic principle of the granting bail, my lord. The Kejriwal, my lord, though in the SSC online, my lord, the judgment of 2 judgment, my lord, one is Suryakant and Ujjal Bhuya, my lord, that has been separately, my lord, has been published in the same, my lord, in same SSC online. My lord, I'll come to the judgment decision of the Justice Ujjal Bhuya, my lord. Para 30th Mark 1, my lord. Is it September, my lord? In this court, my lord, this court in Kudikanti Narasimhalu versus public prosecutor had highlighted that a bail is not to be withheld as a punishment. The requirement as to the bail is merely to secure the attendance of the prisoner at the trial. This court in Manish Sisodia referred to and relied upon the aforesaid decision and reiterated the salutary principle that the bail is a rule and jail is exception. This court has observed that even in the straightforward open and shut case, bail is not being granted by the trial court and by the high court. It has been held as under. The court further observed that over a period of time, the trial court and high court have forgotten a very well settled principle of law that the bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high court attempt to play safe in the matter of the grant of the bail. The principle that a bail is a rule and refusal is an exception is at a time followed in a breach. On account of non-grant of bail, even in a straightforward open and shut case, this court is flooded with a huge number of bail petitions, thereby adding to the huge pendency. It is high time that the trial court and high court should recognize the principle that the bail is a rule and jail is exception. Para 39. Bail jurisprudence is a facet of the civilized criminal justice system. An accused is innocent until proven guilty by a competent court.
following due process. Hence, there is a presumption of the innocence. Therefore, this court has been reiterating again and again the salutary principle that a bail is the rule and jail is exception. As such, the court at all levels must ensure that the process leading to including the trial does not end up become the punishment itself. This court has emphasized and re-emphasized time and again that the personal liberty is sacrosanct. It is utmost important that the trial court and high court remain adequately alert to need to protect the personal liberty, which is cherished right under Constitution. Here, in this case, and absolutely there's no publicity in this case. Trial court has well reasoned, have considered all material, and moreover, there's no single material eyewitness to establish a case, prima facie case. Even as of now, 6 witnesses has been examined, and out of that, the impugned order which reflected 1 eyewitness or none or nothing, that has also been examined. There's no any implication again. Therefore, my humble respectful submission, no ground has been made out. Therefore, my lord may not interfere with the granted bail granted.
Just reply for another 2 minutes. My lord, my learned friend has said about dollar ram. Dollar ram is of supervening circumstance. In the supervening circumstance, my lord, the future occurrence. I'm not on the future occurrence because I'm not after the bail is granted that he has violated condition. I'm not on that. That is what supervening. That dollar ram has been dealt in Deepak Yadav also. That supervening circumstance cannot be limited to that cancellation of bail. But if the order is perverse, illegal, not judicial, and my lord, in Deepak Yadav case, my lord. Now, my learned friend also has said about the 55 years. My lord, that is a proviso in 37 itself. If it is a woman, and woman of 55 years was granted bail. But he's a man, my lord. A man who committed a crime at the age of 70, now he is asking that, I'm 70, please release me on bail. He could murder a person at the age of 70, now he is want to get benefit. How can he get benefit of his own age when he has committed the same crime in his age? Now, in Deepak Yadav, my lord, para 30, in para 30, dollar ram has been dealt with in Deepak Yadav. That my lord will find in page 17. Now, I'll just shorten A2 just bench of this court in dollar ram laid down the grounds for cancellation, which are so and so. Now, in para 31, it is answered. It is no doubt true that cancellation bail cannot be limited. Para 31. My friend was on supervening circumstances. It is no doubt true that cancellation of bail cannot be limited to the occurrence of supervening circumstances. This court certainly has the inherent powers and discretion to cancel the bail of any case, even in the absence of following are the illustrative circumstances where the bail can be cancelled.
Reading which para?
Reading para 31, my lord.
Oh.
30 and 31 of Deepak Yadav.
30 and 31.
30 and 31, my lord. Here, dollar ram has been dealt. Dollar ram has been dealt. Now, after referring dollar ram, it has come down to 31. That my lord will find in page 18. It is no doubt true that cancellation bail cannot be limited to the occurrence of supervening circumstances. Now, he says that there are no supervening circumstances. And Supreme Court has no, this is not required. This court certainly has the inherent powers and discretion to cancel the bail of an accused, even in the absence of supervening circumstances. My application is under 482, read with 439(2), my lord. 482. Following are the illustrative circumstances where the bail can be cancelled, and if my lord kindly come down to D, where bail has been granted, he has given lot of criteria where bail has been granted ED on untenable grounds, where serious discrepancies are found in order granting bail, thereby causing prejudice to justice, where the grant of bail was not appropriate in the first case, given the very serious nature of the charges against the accused who is entitled for bail and thus cannot be justified, where the order of granting is apparently whimsical, capricious, and perverse in the facts in a given case. Now he says, my lord, what I cannot understand is, he says that I've gone through everything, I've gone through. Now, Supreme Court has said that it doesn't suffice. You have to give it your reason. Now he says 70 years old man. The law doesn't provide it. He can commit a crime at the age of 70. Now he's seeking bail because I'm 70, please release me on bail. But, and moreover, the supervening circumstance, my lord, I have given Narendra Kumar, I mean also, my lord, 2008-13 SEC 584. I have given that said complete share was given by my learned friend, Ms. Jelliam. My lord, here also it says the supervening circumstance, once in para 26 of that, my lord, I have given them. Once it is found that 2008-13 SEC 584. My lord, I can give, my lord, once it is found that the bail was granted on untenable grounds, same can be cancelled. The standard there was no supervening circumstance has no relevance. And my learned friend was also on 439 and 482, my lord. My lord, that part also I'm taking care that also, because 439 and 482 has been explained. Below 2001 6 SCC 338. That's also a part of the compilation I have submitted on the last occasion. I have submitted. Now there are also my it's the Mala Quran C. I have said. Huh? No, this is my copy. It was submitted almost every. My lord, I'll just come to the relevant portion, para 16. Para 16. Para 16 of Puran Singh. We see no sustained in this submission. In the hierarchy of courts, the High Court is a superior court. A restrictive interpretation which would have effect nullifying 439 cannot be given. When Section 439 grants the power of High Court to cancel bail, it necessarily follows that such power can be exercised in respect of order passed by the Court of Session. Of course, cancel bail has to be on principles set out here in above and in appropriate cases. Further, even if it is interlocutory order, the High Court's inherent power under 42 is not affected by the provision of Section 393 of Miller. My application under 482. So it doesn't restrict, because he says about supervening circumstances. I'm also not on supervening circumstances. I'm on the perversity, illegality, and injudicious bail order, which is not tenable in the eyes of law. And Miller, what my learned friend cited is the principle governing to grant bail. Principle governing to, even in Sanjay Chandra case, and even in Arvind Ajrawal case, principles governing to grant bail. I'm here on a bail granted in an arbitrary manner without any reason order. So it needs to be set aside. Cancellation may be for supervening. I'm here to set aside and cancel the bail order. That's my humble submission.
Well, only just regarding 164, my lord. Although there's my respect to Sami, there's no prima facie case, no any material evidence. Just regarding the 164 statement, is not a substantive evidence, my lord. My lord, in this aspect only, I'm giving the citation only, my lord.
Yes,
Right.
not given 164.
My lord, that part, my lord, he's relying on that particular person say this in under 64. Although in the evidence that's not been brought on, but it may not be relevant, but that's why if it is. Otherwise, the subtle principle of 164 statement is not a substantive evidence, my lord. You were in 2006 also. This is also on the same principle that 164 is statement, my lord. Even if it's in brought on record, it is not a substantive evidence. it has to be corroborated by the other material witness matter, independent.
No, the best witness is the
Yes, no.
prosecution witness.
Yes, what the state has to say.
Actually, I feel thirsty now. After hearing long submission of both the parties.
Okay.
Your Lordship, there is no doubt there is a provision for cancellation of bail under 439(2). And here is the case where bail once granted and prayer is for cancellation. I will like to, they have made both long submissions. I would like to point it out this court that both parties, whatever judgment they have submitted is oriented to one purpose. When it can be granted, when it can be cancelled. Concept of cancellation and concept of granting bail are two different concepts which we all know. But concept of rejecting bail and concept of granting cancellation of bail are also two different concepts. So I like to place this one, I will not dwell very much. I will only to the law point. Since public prosecutor role is to assist the court impartially and fearlessly. Their concept was elaborately discussed by our own High Court by division bench in the year 2020. So may I directly take to the relevant portion of the piece?
Yes.
18, para 18. It is page 6 of 10.
Yes.
In Prakash Kumar and others versus Ram Prasad Gupta, 2011, 6 SCC 189, the Apex Court, while making distinction between cancellation of bail and consideration for grant of bail, and also the factor on which bail can be cancelled, observed as under. In considering whether to cancel the bail, the court has to consider the gravity and nature of the offense, prima facie case against the accused, position and standing of the accused, etc. If there were very serious allegations against the accused, his bail may be cancelled, even if he has not misused the bail granted to him. Moreover, the above principle applies when the same court which granted bail is approached for cancelling the bail. It will not apply when the order granting bail is appealed against before an appellate or revision court. Now, just we'll keep following. In our opinion, there is no absolute rule that once bail is granted to the accused, then it can be only cancelled if there is likelihood of misuse of bail. That factor, though no doubt important, is not the only factor. There are several other factors also which may be seen while deciding to cancel the bail. Then we will continue. In Abdul Basid Elias versus Rajus and others versus Abdul Qadir Chaudhary, reported in 2014, 10 SSC, the Apex Court, the next page, distinguish between the concept of cancellation or setting aside the illegal or perverse order of the bail and cancellation of bail on the ground of supervening circumstances, relying on the earlier decision in Puran versus Ram Bilas and another Supra Narendra K. Amin versus State of Gujarat, reported in 2008, 13 SCC. 3 judges bench and Ranjit Singh versus State of AP 2013, reported in volume 6 of SCC. The Apex Court held in paragraph 19 as under. Therefore, the concept of setting aside an unjustified, illegal or perverse order is a different from the concept of cancellation of bail on the ground of the accused's misconduct or new adverse fact having surfaced after the grant of bail, which requires such cancellation, and a perusal of the aforesaid decisions would present before us that an order granting bail can only be set aside on grounds of being illegal or contrary to law by the court superior to the court which granted the bail and not by the same court. Then we will directly jump to the para 21. It was para 18,
Yes.
19,
please.
and
Same,
21.
and what is your submission?
My submission here is when it can be cancelled, when it can be rejected, cancellation of application for
Yes,
cancellation
that is there.
can be
What is your
rejected.
submission?
Yes, Your Lordship.
Yes, your submission.
Oh, 21, May. What is last para? I'm relying upon. Para 21, page 7 of 10.
Yes.
The broad principles deduced from the aforementioned authority may be summarized as under. A. Rejection of bail at the initial stage and cancellation of bail once granted are not the same and they need to be considered on different basis. Now here, B. Overwhelming and very strong ground is required to cancel the bail once granted. C. Bail can be cancelled in the following two circumstances. When the accused misused the liberty of bail or there is any other supervening
We have seen that.
And lastly, here relevant portion is B, C3. When the order of granting bail is suffered from illegality, impropriety, or serious infirmity causing miscarriage of justice for not considering the relevant factor or for taking into account relevant factor. Here, Your Lordship, my submission will be here, no doubt. There's a even Honorable Apex Court just differ in some concept. It doesn't mean that it cannot Supreme Court Apex Court judge cannot pass different order or cannot overrule the earlier order. So judicial property is that if the same court pass an order on similar subject and when division bench order is already there, then judicial property is to maintain the decorum of the same court. This much only I have to submit. I would like to leave it to the court wisdom to pass any order, appropriate order.
Your submission is to cancel the bail granted to the accused, or it cannot be cancelled?
Here it is already granted. Yes, what I try to point out in the judgment is if there is an illegality or perversity, granted bail can be considered by the higher court to either maintain or set aside. That's why I'm submitting before this court that your lordship wisdom will prevail.
Okay, you are leaving it to the court.
Yes, because both of parties are submitted so elaborately that I have nothing more to submit.
Okay. Mr. MGC, Direct Counsel for the petition. I also heard Mr. Titavan, Direct Counsel for the
Two.
respondent accused.
Yes.
Two, okay, Mr. Then Tados, Mr. V. Tado, additional PP for the state, and Mr. Togo for the respondent number two accused staff. Hearing concluded. Judgment.
All right.
It cannot. let it be leftover. They have taken risk. Why to mention in the last day? Why to wait for the last day?
Lordship, in fact, the matter which is listed now, Lordship, that order which has the Lordship passed in item number 7, that will be the same order will follow, Lordship. Only the package will be package number will be different, Lordship. Otherwise, Lordship, if this
No.
matter will not
No.
taken up today, Lordship,
Let it be listed on Monday.
Lordship, then this matter will become infructuous, Lordship. This what I have filed today. That's why I have in the morning I have mentioned that, Lordship. I'm sorry, I'm deeply sorry, but in the morning I have mentioned that the order passed your Lordship in item number 7. That same order will follow here. Only the package number is different. I can assist to the digestion also, Lordship.
No, that I cannot allow.
Lordship, that's right. Only the package number is different. Same order, nothing. Same prayer, same ground, Lordship. Otherwise, Lordship, this entire petition would be Lordship infructuous, Lordship.
So in that case, only it will be as subject, there was no interim, I remember.
Yes, Lordship. Exactly. There is no interim, but only without the leave of the court, they should not finalize. That is the part.
Not be finalized without the leave of the court.
That Lordship.
Let us see this one, NIT.
Yes, Lordship.
Issued on the same.
Yes, Lordship. On the same issue, Lordship.
Same date.
On the same date, Lordship. That is 29 October
No, by which you were
Lordship.
granted.
No, he has not been granted extension, my lord. He is seeking extension now.
Same ground, Lordship. There was a flawed breach collapse, Lordship.
No, let us see the NIT by which
Lordship.
you are the successful bidder.
No,
Yes. Are you the successful bidder of the earlier?
Yes, Lordship.
Let us see that one.
Lordship.
Page 36, my lord.
36. Page 36 is the LOI, Lordship. Issued to me earlier, Lordship, in the first time. Page 36, Lordship. This is the LOI issued to me, Lordship.
No, 36.
Page 36 of my petition, Lordship, that the
36 is, I think, what is this? Others.
Letter of intent.
letter of intent, Lordship.
Are we in the same petition? It's a criminal petition.
We are in a CR matter, Lordship.
This is criminal
PC
petition.
529, my lord.
This is question of the fire.
Let's question.
Page 36 now. Page 36, Lordship. This is the LOI issued to me, Lordship. And thereafter, Lordship, that there is agreement, Lordship.
That date is also same.
Yes, Lordship. Same, Lordship. Only, Lordship, the package is
No.
different, Lordship.
Where is the NIT?
NIT, your Lordship will find. The second NIT, Lordship will find at which
That was 11, the first was 11 August. The
11
earlier case also 11 August.
Yes, Lordship.
There is some difference, I think. It will be difficult now because today is last date and I have to complete the other orders also.
I understand, Lordship, but
It will be difficult.
only
It
the
will be
package.
difficult. No, because there is a package difference and then you have power of attorney, etc. So something need to be changed, which I don't, this court will not have enough time to deal with all those. It will be difficult. Get it listed on Monday.
If your Lordship
Okay.
give me 1 minute, Lordship, then I can just,
Because time, you see, time constraint. I cannot stay whole night here.
Lordship, I understand that.
So those are to be signed, correct?
Yes.
And then send it, and then it has to come back, and it will take me to 8:30,
Yes.
till 8:30. And you see, there is a limitation also,
Yes,
some difficulty. Why you have waited for the last date? Don't wait for the last day. I'm really sorry
Well.
for all these motions. I thought that it will be called.
I'm the
I didn't
other.
remember
Well.
that hearing item.
Yes,
I thought that
Yes.
this can be taken up.
Well.
Sorry.
Lordship.
That's it.
Yeah, Lordship. Lordship, this item number 39 supplementary, this can it be heard on 2nd of December?
It is still there.
It is, yeah. Supplementary.
39. Let's pray for your home.
I'm for the petitioner.
Petitioner. Let's pray for by the Land Council for the petitioner. List this matter after,
On 2nd of December.
on 2nd of December.
Lordship.
Have you informed the other side?
Yes.
Okay. Okay.
Lordship. Today they have mentioned this for supplementary.
Already mentioned,
Lordship.
then,
But Lordship,
then why you are mentioning again?
can it be on Lordship?
No, you have mentioned order pass sign only, the morning you have mentioned.
No, for today, Lordship. The mention for today are for the Lordship.
Oh, today, you have mentioned for today?
Yes, Lordship.
Okay, when do you want?
2nd of December.
Okay. Let's pray for by the Land Council for the petitioner. List this matter on 2nd December.
Yes.
Okay. No.
Obliged.
So really sorry.
Lordship.